My lord, may I have my lord's kind leave? Kind leave to mention an order passed by your lordship on 17th October. My lord, time to file the return by the commissioner will expire on Thursday.
File to?
Time to file the report of the commissioner, my lord, will expire on Thursday. The commissioner had 2 deaths in her immediate family. My lord, that is why it cannot be completed. I was respectfully praying for extension of time, my lord.
Okay. Tomorrow, 2 months.
My lord, may it appear day after so that I can notify the commissioner? I'm grateful, my lord.
When the date is fixed before the commissioner?
Tomorrow.
Tomorrow the date is fixed.
Yes.
So why day after tomorrow? Let it come tomorrow.
Lordship.
Why day after tomorrow? If the tomorrow before the commissioner the date is fixed,
Yes.
let it come tomorrow. Inform the other side.
My lord, other side is not appearing. I'll let it appear tomorrow, my lord. No problem.
But item number 27 on my lord's daily list, my lord. I was humbly.
27.
Yes, my lord. I was humbly praying for extension of time to file my reply, my lord.
Case call. Extension of time. Why you are answering for mentioning? It is in the list. The matter will call it.
The only difficulty is, my lord, I'll be traveling for my mother's treatment, my lord, for a week, my lord.
And it's junior.
Okay, my lord.
Yes.
We had brought on record the people.
We are still, my lord, stuck, my lord, in a situation, my lord, where, my lord, obviously, my lord, the person who has to pay, my lord, will think of, my lord, several ways of, my lord, ensuring that, my lord, we don't, my lord, get to proceed to, my lord, judgment. My lord, we'll recall, my lord, that development agreement which, my lord, they challenged, though we are not in possession of the director, my lord, we went and, my lord, had it stamped. Now, my lord, the minutes was an issue. The, my lord, held that it was really not required to be stamped really and we should proceed. But, my lord, they went up, my lord, before the division bench and they made a submission saying that, my lord, it's not been decided, my lord, whether... A copy of it, okay.
We are given the order, yes.
Because, my lord, relied on, my lord, their admission saying, my lord, that the document is nothing but just a mere assertion of whatever was there. But they relied on our assertion, my lord, saying that, my lord, this document is, my lord, sometimes, my lord, we were unable to, my lord, control the course of proceedings. So, my lord, that's what.
So now it is re-hearing.
Re-hearing. But, my lord, I have, my lord, a suggestion. My lord, I've spoken to my lord. My lord, I'm volunteering because it's not worth it, my lord. Again, my lord, if it's, my lord, holds that it's not going to be stamped, again, my lord, appellate court, again, my lord, right up to, my lord. So this will go on. My lord, on our, my lord, volunteering, my lord, kindly have this document stamped also because we last time also we paid and, my lord, it will be, my lord, more cost effective also. Because, my lord, the stamp will be less than, my lord, the number of hearings, my lord, which we will have.
That's something I was telling him on the first day. He wanted to.
No, but you are stalling it, my lord. I only one request. If, my lord, kindly directs, my lord, the stamping authorities, my lord, to do it within a particular period as soon as possible. Because they've already dealt with, my lord, the development agreement. Whether, my lord, this at all, my lord, requires, they can, my lord, decide on that. And, my lord,
but the original has to be handed over by them to my lord's officer. Only after that it can be sent.
Where is the original?
No, how can it be? It has
no,
to be sent
original
through court.
will be sent there.
It has to be sent through court.
No, that's what happened last time also. Last time that we also.
It will
be sent to the. It will be
by the department.
Deposited before the register.
And only I was praying, my lord, if kindly fixes, my lord, a time limit for this to be done because this has already been dealt with by them. Otherwise, my lord, and in the division bench, of course, my lord, there was a request, my lord, that the whole matter be heard, my lord, by end of. Yes, there is.
Not the whole matter on this.
We are not very sure, but that's what it seems, my lord. It seems, my lord.
Said decision.
No.
Said decision.
That's why Mr. Mitra is keeping some other points.
Yes, yes, my lord, that's my fear, my lord. I don't know what else will come up.
Many more points will come.
Mr. Mitra's ingenious, my lord, I have never doubted. My lord, I have known him, my lord, for quite some time now. My lord, I do not doubt that. My lord, I do not doubt that. My lord, I admit defeat, my lord, when I see it. I'm, my lord, willing to have it stamped, my lord. That's what I advise them because we will spend, my lord, 4-5 hearings on this only. Again, my lord, appellate court. Poor client, but he will spend much more than, my lord, what will be the stamp duty, my lord, so far as this is concerned. Well, I really don't know how to advise anymore. Because I was quite sure what we did was correct. That was not required to be stamped. But in view of again sending it back, again we'll have
say that it not has to be stamped.
again 3 hearings before my lord. Only on this. And whatever we decides, again they will go up in appeal. Again will be back. So I am volunteering that if it is sent to them, only that request is the time limit. Last time also, I am told the original document we went and submitted before the collector.
The procedure has to be impounding means through the court.
Let's not.
It has to.
You have taken a point. We are wanting to have it stamped
That's
down.
the law. Follow the law, then there will be no problem. Now, section the.
Last time that was not the issue which you took up. The order is on the last occasion. 29 March 2023. I have a bunch of the orders.
Where is the last order?
My lord.
Where is the last order?
Of the yes, this is here. This is the order. This is the 29th, page 29. Right.
Which document? Page 44. Page 44, which you wanted to.
Yes. I think it's referred to here, my lord. Correct. No, development agreement was 27th August.
That is over.
Yes. Now, my lord, the other one is that's
the meeting.
Yes, minutes of the meeting, 9th.
41. Page 41.
Page
41, I think so. In the
no, here also it's referred. Yes, my lord.
Page 41. Minutes of the date.
In fact, in this, yes, in this order also, my lord, refers to it, my lord. 9th May 2017. Page 34, my lord, refers to this also. Then, my lord, nothing taken.
No, it was.
Yes, Mr. Mitra, any submission?
Any other points, my lord? I think that should be the question, my lord, asked.
Points will come in due course. Don't worry, Mr. Manager.
Admitted 7 crores plus interest, my lord, he will not pay. We have, my lord, understood, my lord.
Yeah. That too.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. This court, by a judgment dated 22nd September 2023, has disposed of GS7 of 2023. Has dismissed the GS7 of 2023 filed by the defendant. Wherein filed by the defendant. Being agreed with the judgment dated 22nd September 2023, the defendant had preferred an appeal. Being APOT number 387 of 2023 with IAGA number 1 of 2023. Full stop. The appeal preferred by the defendant was disposed of by the Honorable Division Bench, wherein the Honorable Division Bench had set aside the order dated 22nd September 2023 and remanded the matter back to this court to decide the question de novo on the basis of the observation made by the appellate court in the order dated 17 November 2023. After the order passed by the appellate court, the concept for the plaintiff submit that the plaintiff didn't want to go into the controversy whether the document is required to be stamped or not, but the plaintiff voluntarily intend to send the document for to be properly stamped. In view of the submission made by the learned counsel for the plaintiff is directed to submit the original minutes of the meeting dated 9th May 2017 before the registrar original side of this court within a week from this court within a week from this day. And after submission of the original document, the registrar original side is directed to send the said original minutes of the meeting dated 9th May 2017, 9th May 2017 to the collector for valuation as provided under the Indian Stamp Act 1889. And after valuation by the collector, the plaintiff shall pay the said amount.
May I just make one request? Mulad, the last order, if Mulad looks at Mulad, page 46. Mulad, this is what Mulad had directed in view of the above, the agreement dated 27th August is referred to the collector for valuation. So Mulad, last time we directly went to the collector, Mulad, and Mulad presented for valuation.
That the original side will send it to the collector and he will value the property and proper he will stamp.
Well, last time it didn't go through that process.
So you wanted to directly.
I directly, Mulad, I'll go to the Mulad, the collector. I directly go to the collector. No, you did not object to. I'm volunteering. That's why it's going directly to the collector.
Provides that will be sent by the court.
Yes, that's
Mulad, this is not the last order.
no, that was done. They are not challenged. You have done this. But if it is voluntary, then it is to be sent to the court. It is to pay.
Mulad, this is again Mulad delay the Mulad whole process. That's my only fear. Mulad, only fear. Mulad, kindly provide the same direction. We will go because it's in our interest. We will immediately Mulad go to the collector Mulad with my lord's order. Mulad with my lord's order and Mulad have it done.
But the original is not here.
Original Mulad, we have it original. We'll have Mulad, we'll give it to Mulad, we'll give it to the collector immediately.
So today, and I am passing an order. Today, the petition plaintiff will submit the order by tomorrow, and immediately the registrar will send to the collector, and collector will take up a petition for valuation.
Mulad, again Mulad, time Mulad will be consumed. Mulad, if the registrar Mulad, it's the same Mulad. I am having it voluntarily Mulad. I am volunteering it Mulad to be stamped. It's not a question of Mulad court Mulad impounding it also.
In view of the submission made by the counsel for the plaintiff, the minutes of the meeting dated 9th May 2017 is referred to the collector for valuation as provided under the Indian Stamp Act. Full stop.
That they will decide. Mr. Mitra can't.
The collector is directed to properly stamped after valuation and send the document back to the court within 2 weeks from
I'm so
the date
grateful.
of receipt of
I'm
the
so
document.
And Mulad, only one request Mulad I'll make Mulad when we come back. Mulad, these documents have not been formally Mulad marked as exhibit.
Now,
Mulad,
once it has been
yes, Mulad, that point also they took there. Saying Mulad, it's not been marked as exhibit. I said that's how we are proceeding.
no, that's why because in the first order, I think they
Yes,
not
yes, because they
shown-
agreed. Absolutely.
because when the case was fixed for hearing, on that day, Mr. Sabyasachi
Yes,
Chaudhary
yes.
has stated that he will not adduce the
Correct,
evidence
correct.
and he will argue on the basis
Correct,
of the
correct,
document.
correct.
Then this court has taken up for the matter hearing. Then Mr. Mitra has taken the point of the stamp of the agreement.
Yes.
Then that has been decided. Okay, whatever it is.
And then Mulad, they took all this. I just want to protect myself. And Mulad, unnecessarily Mulad, hassling Mulad, the court. Mulad, we'll be back.
Let
Mulad,
the
I'm so
matter-
grateful.
Let the matter appear on
With the order as soon as you get the order.
will appear on
I'm grateful.
11. 9th of January. 2 weeks.
2 weeks. Mulad,
Vacation also. So
Mulad,
11th, 20.
today is one of the 11th.
Today is 11.
2 weeks,
18,
25th.
9th or 9th of January.
9th of January. 2 weeks both. I'm grateful, my lord.
No, for orders.
Your Lordship, recollect, my lord, this matter was mentioned by the defendant on the account of non-payment of, my lord, fees of the erstwhile advocate, my lord. My lord, last time the matter was mentioned, my lord was very clear. Either settle the dues outside the court, or my lord will pass necessary orders. My lord, what they did, they made payment only one bill. Made payment only single invoice out of the 8 invoice pending. On Friday at 2 o'clock, when there was a resolution, my lord, the representative came and casted aspersion against me that they have paid all the bills and have willfully withheld the NOC. Well, this is not the case, my lord. I'll just produce the 2 documents, my lord. My lord, if my lord kindly sees this.
This court will not.
My lord, I'm not calling the court, my lord. I was just asking.
I am giving a week time. Either you provide no objection. Otherwise I will accept the vakalatnama.
My lord was pleased to settle the dues, my lord.
The matter is listed today and listed today has to be mentioned on the prayer made by the defendant. Full stop. It is the defendant intend to change the advocate, as the erstwhile advocate is not intending to continue with the matter. The learned counsel for the defendant, who had earlier engaged in the said case by the defendant, is not providing the no objection on the ground of non-payment of his bill. Full stop. This court granted a week time to the parties to settle the issue. Otherwise, the vakalatnama of the new advocate shall be accepted, so that the matter can be proceeded further. List the matter on.
Your lordship, it is already made returnable on 18th.
2023. Has to be mentioned.
My lord's pleasure, I'll give the NOC, my lord.
I don't know. That's why I'm giving 1 week time, and this court will not sit with you.
My lord.
Settle your fees and all the.
My lord.
You settle because the court cannot
My lord.
say.
My lord. Well, we are not called even to the
So you
court, my
do
lord.
that.
My lord.
If you are not paying your other authority,
My lord, I'll do
other
that.
remedy.
My lord, I'll do that. Oblige, lord.
I'm for the petitioner, my lord. Lordship, I am here for the defendant. I am praying for short Passover, Lordship.
Passover. Next.
Lordship, I am for the respondent in this matter.
Yes.
My lord, I'm for the petitioner.
Who's for the plaintiff? You are for the plaintiff?
Yes, my lord.
Yeah, where is your witness?
My lord, I need a short Passover.
Huh?
I need a short Passover.
Why?
My lord, the senior is on legs. My lord is coming to this court.
Passover. Next. Item number 7.
My lord, in item number 7, I appear for the plaintiff.
Yes.
If my lord kindly takes up the last direction passed by my lord on
You are for the
November
plaintiff?
17th. Yes, my lord, I have appeared for the plaintiff. My lord, the defendant appeared on that date and sought liberty to file their vakalatnama on the next date. My lord granted such opportunities, and there was a direction upon us to serve a copy. My lord, we have done. This is the copy of the letter.
Yes.
I believe they are not much interested.
What is the stage of the suit?
My lord, summons has been served. They have received.
Not filed,
my lord. They have appeared on the last occasion after receiving summons. Another copy was served on them of the plaint with all the
Why
annexures.
2018 now the summon was served?
Because my lord, in there was defects were identified in this matter in the plaint, and within that period there were
I am
COVID.
fixing after a month, if they will file return statement, otherwise suit will proceed.
My lord, my lord.
Counsel for the plaintiff is present. None appears on behalf of the defendant. Counsel for the plaintiff is handed over the communication dated 17/11/2023, wherein it reveals that the plaintiff has complied with the direction passed by this court by supplying the copy of the plaint along with the document to the learned advocate for the defendant. By an order dated 17 November 2023, the defendant is given liberty to file wakalatnama by the next date fixed. Today, neither the defendant had appeared nor any information is furnished whether the defendant has filed wakalatnama or not. For the interest of justice, the case is adjourned till
Lordship,
16.
I'm for the respondent.
Have you filed wakalatnama?
Yes, Lordship.
Have you filed the written statement?
No, Lordship, praying for time to file.
Okay, I am fixing on 16 January. By that time, you file defendant number 3. Have you filed wakalatnama? Have you filed written statement?
Yes.
Let the matter appear on 16 January 2023. The defendant is
Number
liberty to file their written
There is no
statement.
defendant number 3 in this matter.
Okay, you file the written statement by 16.
Appearing in item number 7.
OD.
They have appeared.
This is commercial division.
It is
Commercial division.
stated.
My lord, there is no defendant number 3 in this matter, my lord. There is only one
Which
defendant.
matter you are appearing?
Your Lordship, I'm appealing for SBI card, Your Lordship.
Huh?
My lord, I don't know matter.
Lordship, it might be in Delhi list.
Lordship, I'm sorry.
Sons appearing for the plaintiff, sons appearing for the defendant. The counsel for the plaintiff and defendant submitted. The counsel she has filed the wakalatnama for the defendant and pays for time to file the written statement. Let written statement be filed within 30 days. Let the matter appear on 16 January.
Grateful.
My lord, I'm appearing on behalf of plaintiff number 1 and I'm being led by Mr. Jishnu Shah, who's appearing virtually, my lord.
But I appear for the defendant number 1. There are 2 applications on board, but I need to file affidavits in opposition in both these applications.
Deletion of the name of the defendant from the cause title of the plaint.
Yes. Well, insofar as this application is concerned for deletion of the name, my lord, I'll be very candid, my lord, there is no instruction from the client. But my lord, we don't want to take a chance. We'll file a formal, my lord, opposition to this application.
How many applications, how many GAs are there?
Lordship, GA 8 and 9 are filed by plaintiff 2 and GA 10 and 11 are by plaintiff 1. They are identical applications.
What are the applications? Same.
GA 8
Same,
and GA
same.
10.
All the applications you want to file
Yes.
for deletion of the name. All you
But
take
on
is that
deletion of the name, I don't think there can be any
same
objection.
applications are there for deletion of the name.
The Lordship kindly give us the shortest period of time. We'll file an formal opposition.
For
My lord.
deletion of
Well,
the
it's the bank. My lord, I don't want to take a chance. But in the other application, my lord, I have got instructions to oppose.
she's telling that all applications are the similar in nature.
No, my lord, 8 and 9, 10 and 11 are similar.
GA 8 and 10 are for deletion, my lord. Those are identical. GA 9 and 11 are for additional documents to be brought on record. Those
The
are
additional document will be opposed.
Lordship, I'm
Regarding
Vehemently oppose.
for defendant number 3.
what is the submission?
Lordship, we don't have any objection to their application.
Sons appearing for the plaintiff, sons appearing for the defendant number 1.
What? Yes.
And who's for the defendant number 2?
Defendant 2's name has been deleted, my lord.
Appearing for the defendant number 3. The plaintiff has filed GA 8 and 9.
8 and 10 for deletion.
Plaintiff has filed an application being GA 8 of 2023 and 10 of 2023 for deletion of the name of the defendant number 3.
Number 3.
Defendant number 3. Plaintiff has also filed an application being GA
9 and 11.
9 of 2023, 11 of 2023, praying for submission of additional document. Police counsel for the defendant number 1 prays for time to file affidavit in opposition in all applications. Let affidavit in opposition be filed within 2 weeks.
My lord, 2 weeks.
reply if any there to be filed within a week thereafter. This is the matter on 16th January.
Lordship, the reply may be filed 1 week after the reopening.
After submission of 2 weeks, 1 week.
That might be in the middle of the.
That's why
I was appearing for the plaintiff number 1.
Yes.
I was appearing for the plaintiff number 1. My lord, I'm sorry, I'm appearing virtually today.
No problem, no problem. Mr. Swanson, appearing. Yes.
Grateful.
My lord, I appear for the plaintiff, my lord. Suit for, my lord, passing off infringement of copyright and, my lord, infringement of designs. That, my lord.
I am appearing on behalf of the defendant.
So the matter is appearing as an ex parte, my lord. Matter was set ex parte long time back. Possibly, my lord, my learned friend cannot have any say today.
Have you paid the payment amount to the receiver?
Yes, my lord. Done.
Remuneration you have paid?
Yes, paid. My lord, before I trouble your lordship with the main matter, if lordship kindly takes my plaint, paragraph 4, my lord, there's something, my lord, which I need to bring it to my lord's attention first. At paragraph number 4, my lord, I have pleaded. No. My lord, the case of the plaintiff, my lord, is that the plaintiff has been using the mark since the year 1993, save and except for a brief period. If my lord kindly turns over to page 4.
14 to 16.
2014, because, my lord, what had happened, my lord, there is a suit which is pending before the Honorable Bombay High Court, my lord, which had been filed by one Sumit Engineering, my lord, Sumit Appliances Private Limited, my lord. My lord, in that suit, my lord, I was injuncted. My lord, I did something which I shouldn't have done. My lord, those orders, my lord, I'd like to place it before, my lord, before I proceed with my matter. The suit was actually filed in the year 2011 from 2011 till 2014. There was no injunction against my lord. I was the defendant there, my lord. Lord, these 3 orders, if lordship kindly takes this, my lord kindly takes the first order. My lord, order passed by Honorable Justice G.S. Patel on September 1, 2014, my lord. If lordship sees first paragraph, this is an application for urgent ad interim reliefs. The motion is of 2014, the suit is of 2011, and the trademark infringement action combined with the cause of action on passing off. Now, if my lord kindly turns over to paragraph 3, my lord. At the time when the suit was filed, the defendant was said to be using the name or word as the plaintiff's registered trademark with a slight variation. The plaintiff's trademark is Sumit, my lord. Yes. This is represented in a very stylized manner in a distinctive getup or trade dress in which each letter is uniquely and graphically depicted. The depiction is not strictly speaking of a special font so much as the graphic design of each character in the word. The original offending mark used by the defendants used the same word with the prefix "mi", my lord. This has been my case, my lord, which I've. The depiction was originally also marginally different. Now, my lord, this is where, my lord, I was at fault, my lord. Paragraph 4, my lord. It appears that no injunction having been granted and possibly emboldened by this, the defendant now has started using a different mark. The plaintiff's mark is at Exhibit A and the defendant's competing marks shown so and so. If my lord now kindly turns over to page 3, my lord, this is what, my lord, this was the mistake which I did. My lord, I have to be very candid. My lord, lordship sees the first label is of the plaintiff there in that suit, my lord. My lord, this was my mark, my lord, which continues to be my mark, the second mark. The third is what I had changed. If lordship sees, my lord, what I did, my lord, I changed the font, the stylite, and I started copying plaintiff's mark. This was a wrong committed by me, my lord, and rightly so, my lord. The Honorable Bombay High Court injuncted. So, my lord, this is the order of injunction, my lord. I will not trouble lordship with this. Thereafter, my lord, if lordship takes the second order of 17 June 2016, my lord, there, my lord, I was personally present, my lord, and I gave an undertaking to the Honorable Court that I will not use the mark. Now, my lord, is the third order, which is very important, of 12th August 2016, my lord. My lord, this was, my lord, I had preferred the review, my lord, because the plaintiff themselves did not have right over the mark, my lord. Because the company had long back, my lord, had gone into winding up. The lordship sees, given the quite extra, paragraph 4, my lord, given the paragraph 4, my lord, given the quite extraordinary facts of this case, there will have to be an ad interim order in terms of prayer
clause B staying the effect, operation and implementation of my orders dated 28th October 2015. I may note that there is a previous order dated 1st September, my lord, which I just placed. That was an ad interim order. It merged into the 28th October 2015 order. Given the fact that this is a review petition and that I am not only admitting it but also granting interim relief, it is necessary to at least briefly set out the facts. Prima facie, it appears that the respondent to this petition, the original plaintiff in the suit, obtained orders on a completely, because the plaintiff himself was not entitled, on a completely incorrect basis, asserting that it had rights to the trademark in question. The review petitioner, that's me, my lord. The review petitioner has found that these statements, including the statements made on affidavit, were demonstrably incorrect, and these have resulted in a wholly incorrect order of this court. It is for these reasons that I have granted ad interim release, my lord. Paragraph 6, my lord, the application today is not for ex parte release without notice. The review petitioner sought to serve the defendant. The company's address was found logged at the residence of the director. Service was actually refused. An affidavit of service is filed taken on record. And my lord, so my lord, my review is allowed. The interim order which was originally granted, my lord, restraining me, my lord, was vacated.
Where is that?
Well, this one, well, this is prayer A. Paragraph 4. Paragraph 4.
Achha.
There will have to be an ad interim order in terms of prayer clause B staying the effect. So, my lord, the order by which, my lord, I was injuncted was stayed, and my lord, it continues to be so. Suit is pending so far, but my lord, there is no restraint order. So, my lord, save and except for this brief period, my lord, from 2014 till 2016, my lord.
Then what has happened finally in the review petition?
Review petition was allowed subsequently.
7th October 2016.
It was fixed, my lord. I do not have the my lord.
This is an interim order.
This is interim order, my lord.
That was confirmed in final.
My lord, subject.
Where is that order?
I do not have that handy. Right. Sorry, my lord.
You have to bring that.
Yes, I should have.
What is the order, last date of the order? Because this is the order dated.
This is of 2016, 12th of August 2016, my lord.
Where is that?
My lord, first page, lordship, see?
Yes, 12th August
Dated,
2016.
my lord.
And injunction for September 14.
No, my lord, 1st September, which eventually merged, my lord,
That you have stated.
20th October 2015, my lord.
But you stated 12th October, yes. 12th August.
Well,
no, the first injunction order 1st September.
1st September 2014, my lord, which was eventually, my lord, which eventually got merged in another order of 28th of October 2015, which, my lord, will find at paragraph 4 of the order dated 12th of August 2016, my lord.
Huh.
My lord, but then thereafter,
Then what has happened finally in the review application?
my lord, I on instructions, my
you have to obtain it.
then
Mr. Dilip Kumarji, an advocate appearing for the petition. And Mr. Rajiv Jain, sorry. Rajiv Jain, an advocate appearing for the petitioner. He has handed over the copy of the order passed by the Bombay High Court in suit number 1184 of 2011, dated 1st September 2014, 17 June 2016, 1st September 2014, and 12th August 2016. Let the same be cut with the report. And at counsel for the petition plaintiff, prays for time to place the final order passed in the review application. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter up when? 2 weeks or 1 week?
1 week less.
Let the matter appear on 19th December.
No, my lord, 19. I have some difficulty. Can it be on 20th instead?
Okay, 20th.
20th. Grateful, lord. Oblige, my lord.
The to be mentioned matters in the non-commercial. Item number 2 is just a 1 minute affair.
Yes. Yes.
Well, this is for extension of time to complete the commission. Well, the other side is here. I'm told, my lord, they have no consent if the time is extended till the 31st of March.
There are no consent.
They had said they had no objection.
We have no objection, but as it's a government company, no, we shouldn't. There shouldn't be any consent given. That's why.
No, don't write the word consent.
Yes, like, Your Lordship, please don't write the word consent.
The matter is item number 1 of the original set. Then
item number
Item
2.
number 2, non-commercial list.
Turner Morrison, yes, 2 and
only 2.
Counsel for the plaintiff and the counsel for the defendant are present. The matter is this has to be mentioned on behalf of the counsel for the plaintiff. By an order dated 23rd June 2023, 20th December 2022, this court has appointed commissioner for conducting inquiry and to submit report by 12th of December 2020. Counsel for the respective parties submitted. The learned commissioner is conducting the inquiry and has not yet been completed. Learned counsel for the plaintiff prays for extension of time to submit report by the commissioner by 31st of March 2024. Counsel for the defendant raised objection. Submit that since the month of December 2022, and in the month of December 2022, this court has passed an order for holding commission, but 1 year has been passed. The commission has not completed the commission. Concerning submission made by the counsel for the respective parties, this court find that one opportunity should be given to the learned commissioner for completing the inquiry. But the action passed by this court, accordingly, for the interest of justice, time to file the report by the commissioner is extended till
Well, the 31st March, subject to my Lord's pleasure, my Lord.
Sunday and then 29th,
Oh, I'm sorry.
29th of March.
29th of March.
29th of March.
I'm grateful, Your Lord.
Well, even in item number 1, though the other side is here, it may come back to my Lord. My Lord had directed Mr. Jishnu Chaudhary to be present. He was the commissioner because there was
a fixed matter be taken.
Very.
Well, the only thing, my lord, in item number 1, possibly I will have to ask for an adjournment because my advocate on record, Mr. HON'BLE, is admitted in Apollo, my lord, with malignant malaria.
So when can we fix?
But maybe a week hence, my lord.
Well, this is, I am not
Just a
standing in the
weekend.
way, but my Lord, let it be a week hence marked at 10:30 because it's a
Yes,
2-minute matter
Let item number 1
of
as
to
per
be
the prayer
mentioned.
made by the counsel for the defendant, let the matter appear on 19th.
My
19th.
My lord.
My Lord, let it be at 10:30, my Lord. Let
It's to be mentioned in the
To be mentioned.
very well.
Lordship,
Then let it retain its position.
29th March 2024.
Let it retain its position, my Lord. I'm very grateful.
Well, in this connection, my lord, may I be permitted also?
No, no,
Lordship,
fix. I am taking
Well, item
fixed
number
matter.
5, only 1 minute, it will be required.
Lordship, item number 7.
टमाटो फटा है ना, बैठा है कि नहीं है देखो, बोला इसको यहीं बैठना है, अंदर क्या Yes.
My lord, on the last occasion, I had dealt with 3 points which were raised by the defendant and number 1 in their argument, and I have tried to demonstrate before your lordship, my lord, that the points which were taken by my learned friend in the argument were not there in the pleading, neither were they brought in by way of evidence. In any event, if they are not there in the pleading, my learned friend cannot take those issues at the stage of argument, my lord. My lord, very swiftly, my lord, I will like to touch the further points which were tried to be agitated by the defendant number one in their argument, my lord. Well, the first thing, the first point which I would like to harp on today is, well, it was argued on their behalf that it was not a fact that there was an oral agreement and the mutual non-disclosure agreement came as a supplement to the oral agreement as has been pleaded by the plaintiff in the plaint. And while making that submission, my lord, my learned friend had referred to the emails dated 18th of October 2014, 19th of October 2014 and 24th of October 2014. I have already placed those on the last occasion. My lord, I had specifically stated that there was, and the mail, first mail, 18th of October 2014, if it is taken up, my lord, the very first line is, as per our discussion, which indicate it was a mail which was issued by the defendant number one and which clearly indicate that there was a understanding and oral discussion, negotiation which took between the parties, and pursuant to such discussion, the format of the mutual non-disclosure agreement was being forwarded to the plaintiff, which the plaintiff also modified and sent back on 19th itself. And on 24th of October was the first offer which was regarding the properties were sent to the defendant number one, my lord. My lord, on the last occasion, I have also demonstrated before your lordship, my lord, after receiving
Next Tuesday, 19th. No problem. 19th. Yes.
my lord, I have demonstrated before your lordship, my lord, when the 24th of October, when the first offer was made, it contained terms and conditions that this is the remuneration which the plaintiff will be entitled to in the event the deal is completed. My lord, it was argued on behalf of the defendant number one that each such offer was unique in its own nature, and when it failed, there was no other, it had no nexus to the other the offer that was made, and in any event none of those offers were culminated into a finalized deal. So they were separate offers which fizzled out. So there was no agreement between the parties. That is the stand taken by my learned friend, the defendant number one, my lord. But I have demonstrated before your lordship, my lord, on first occasion I sent, second occasion I said he accepted my terms and conditions. For the sake of argument, I am taking it that it was in respect of that particular offer. But he knew the remuneration or the consideration I would be charging in the event the deal was completed, my lord. Then I have shown your lordship that after a few such proposals, there came a proposal from their end, then whatever I have to offer them, it has to be in their format. And in the meantime, the mutual non-disclosure agreement was also proceeding. So, my lord, the mutual non-disclosure agreement was being worked upon. I was making my offers one after the other for the consideration of my...
already on record.
Yes. My lord, the moment I was asked to give it in the format of the defendant number one, that itself indicates the understanding, the agreement between the parties. And thereafter, I could not have given my consideration, but the terms of my consideration, because That format did not have that particular column.
Yes.
So, my lord, this point raised by my learned friend is not sustainable. My lord, the next point was, since the master circular agreement was entered into by and between the defendant number 1 and 2, the defendant number 1 did not think it was necessary to take my assistance or services, but the admitted position is that there was no communication from the defendant number 1's end. I was never intimated, and that has been admitted in the written statement. I had no knowledge of that. I was not, there was no privity of understanding between myself, the defendant number 1 and the defendant number 2. And I have also demonstrated before your lordship, my lord, that the defendant number 1 was time and again taking my assistance even after finalization of the master service
That is
agreement.
the that is the
Yes.
agreement, and that is the evidence.
That, my lord, the third point raised by my learned friend was, this particular property, which is the suit property, Srirampur property, was brought to the notice of the defendant number 1 by CBRE. That is also the stand taken by the defendant number 2. My lord, I will take the opportunity of dealing with both the defendant number 1 and defendant number 2 submission in respect of CBRE, my lord. Both of them have failed to bring on record one iota of evidence
Whether they are
wherefrom it would be apparent that CBRE was the one who showed them the property, or from whom they got the particulars of the Srirampur property. On the contrary, my lord, I have demonstrated before your lordship, my lord, that even after the agreement which was entered into by the defendant number 1 and 2, this property was offered by me.
Yes.
Documents were received by the defendant number 1. The defendant number 1 further asked for documents and pictures, photographs. I have forwarded that also. And upon receiving that, the defendant number 1 had also asked for the postal address and inspection, my lord. Thereafter, the defendant, it is an admitted position that the defendant number 2 was introduced to me by the defendant number 1.
Correct.
And the defendant number 2, with the defendant number 2 also, there was oral
agreement,
discussions and negotiations. The very first mail which was received by the plaintiff from the defendant number 1, the opening lines are, as per our discussion. My lord, I don't want to take your lordship back to those documents. It would be wastage of time. I don't want to waste time anymore, my lord. I have already many a times I
have taken note of it.
So, my lord, it is an admitted position that the defendant number, I came to know the defendant number 2 through the defendant number 1.
It is your case also.
And it is their case also. They also admitted. The defendant number 2 also the defendant number 1 also admitted that they had introduced me to the defendant number, but he had Mr. Prasad, he was the one who referred the plaintiff to the defendant number 1.
Correct.
Now, their ground, their case they are trying to make out is that since I was not in requirement, I introduced the defendant number 2 to the plaintiff so that the defendant number 2 can interact with the plaintiff. Why? What was the reason? Because the defendant number 2, as per the defendant number 2's case, was in regular interaction with CBRE. I was not required. CBRE, according to them, was their working partner. So they had no need to contact me. But they did. Today, I have demonstrated, it is an admitted position, the entire know-how of the property was received, that is admitted also, was received by the defendant number 1 as well as the defendant number 2 from me, which culminated into a deal behind my back. But there's the claim made by them that they got it through CBRE. has not been proved by way of any evidence, either documentary or otherwise.
As per your case, the document which you have provided, that was been concluded with the defendant number 2.
Admitted position, but it is admitted by both the defendant number 1 and defendant number 2 that they received.
But the defense they have taken, they obtained the CBRE.
From CBRE, but it's not proved at all. Now, my lord, the stand taken by the defendant number 2 is that, as well as the defendant number 1, the agreement between, since I have said the case made out by the plaintiff is that the defendant number 2 was an agent to me. He represented himself to be the agent of the defendant number 1. That is how the defendant number 2 was introduced to me. Both the defendant number 1 and defendant number 2 say that no, they had a principal to principal agreement. One was not the agent of the other. Correct. How am I supposed to know? What is there on record which they have shown, from which it would appear that I was aware that they had a master service agreement between them, was a principal to principal agreement, and one was not the agent of the other, and defendant number 2 was interacting with me in its individual capacity. Nothing of that sort. Nothing on record. On the contrary, it is an admitted position that I was not aware of the master service agreement. Now, my lord, another point has been taken by the defendant number 1 that I have not made the warehouse owner a party. My lord, I was not required to make the warehouse owner a party, because it was the defendant number 1 with whom I had the mutual non-disclosure understanding.
Now, their case, the submission which they have made as per the first mail and the first condition which you have given, the term is that some amount is to be paid by this and the owner. That's why if the owner has not been party, how you can claim the amount?
That is what I'm trying to explain, my lord. My lord, had they not taken this exercise behind my back, I would have been there to claim 1 month's lease rent from the warehouse owner and 1 month from the defendant number 1 or defendant number 2, whoever it is. But that was not done. They have already entered into the agreement. It was the defendant number 2 and the defendant number 1 who have defrauded me. The warehouse owner, I have no cause of action against the warehouse owner. The warehouse owner did not have any understanding with me. There was no mutual non-disclosure agreement with the warehouse owner.
Yes.
If I had made him a party, what would be the cause of action I had against him? Nothing.
So you have no transaction with?
Yes. The warehouse owner had not committed any breach against me.
Yes.
It was due to the acts and actions of the defendant number 1 and 2 for which I lost out. And now it is them who would be liable to indemnify me for the damages I have incurred. So, my lord, in my respectful submission, I could not have made the warehouse owner a party.
Yes.
Now, my lord, the rent, the rate, the share, the rate of rent that I have claimed, it has been stated by the defendant number 1 that I have not proved the rate. My lord, I was not required to, because my proposal, which was admittedly received by the defendant number 1 on 31st of December, and having gone through that proposal, he had asked for further documents. So, my lord, he has accepted the terms and conditions which I had forwarded to him. That is the basis on which I have made the claim.
Yes.
The proposal which I had forwarded was accepted by him, pursuant to which he had further asked for documents, and after receiving those documents he had further asked for the postal address. So he has never once said that, look here, this is not the rent.
The amount mentioned in the agreement, is there any
But you will
amount?
give me, yes, 1
Is
minute
there any
time.
amount
I
mentioned in the
will.
agreement with regard to the rent?
But should we give me 1 moment's time on it? I'll just say 31st December, the mail that was forwarded. ₹20 per square feet. What is the area? It was ₹20 per square feet. And the area that was offered was 7,000 বোধহয়। এই 31st ডিসেম্বর যে এটা আছে ওটা এখনো আমি খুঁজছি, হাতড়ে যাচ্ছে। হ্যাঁ, পেয়ে গেছি তার। My lord, your lordship will take up the judge's brief of document, page 250. Your lordship has seen 31st December 2014 email from the plaintiff to the defendant giving the attaching the offer of the Keola property, my lord.
Exhibit U.
251 carpet area of the building, 80,000 square feet.
80,000 square feet, yes.
And my lord, 252 expected rent,
20
rupees 20 per square feet. And that is the basis on which I had made my claim. Now, my lord, on the last occasion, your lordship had also put a question to me that how long did was there correspondence with the defendant number 1? My lord, as late as 22nd of April 2015, page 263, my lord. Twenty-second of April, I am still writing to him for the mutual non-disclosure agreement, my lord. They are receiving it. No answer.
Yes. So what do you want to say?
266 also, your lordship will find. 2nd July 2015. Reminder for mutual non-disclosure. By that time, I have come to know that They have already entered into an agreement, my lord.
Whether their agreement which was entered between the parties they have exhibited
The master service agreement,
between them.
yes, my lord, it was exhibited by the defendant number 2.
Yes.
And my lord, there were questions were also put on in respect of that, where subject to correction by my learned friend, my lord, the defendant number 2 failed to prove that the claim made by the defendant number 2 that they were working on voucher to voucher basis. That they failed to prove. That principal to principal contract, voucher to, which I have already shown your lordship, my lord. I don't need to go into that anymore.
And what is the rate in their agreement between 1 and 2?
That they have not disclosed.
Not disclosed. That's why I'm asking. They are not
No,
disclosed.
no, that we are not.
Yes.
My lord, it was also orally submitted by the defendant number 1 that the entire agreement was brokered by CBRE. Again, at the cost of repetition, I say that nothing has been proved. My lord, I would not like to go into the details of the evidence because I have extensively taken your lordship through the evidence.
You have pointed out all the things.
All the
with
things that
regard
were
to the
required to
print
be
and the
taken,
documents
my
and
lord.
the exhibit. They have also pointed out all the things which there with respect to the
Yes, my
case.
lord.
No,
And whatever little indications I have to make, I will do so in my written notes of argument, my lord.
what about the judgment?
My lord, I'll just make my submissions very fast through about the stand of the defendant number 2, which according to me, my lord, is very palpably the baseline of their defense is that they were not the agent. CBRE was the one who had given them all the instruction. They have also went one step further, saying that they had called us as a courtesy call because defendant number 1 was their prime customer, and as per their instruction to please the defendant number 1, they had interacted with me with regarding that crop as a courtesy. Hello. First of all, that statement is itself is an admission that they had interacted with me. Secondly, my lord, they were also a business house and they were quite aware that we were interacting on commercial basis. Having known that, there was no place for any courtesy call by the defendant number 2 to the defendant number 1 with the plaintiff.
And that is not the case in the written statement.
And they have not made out such case. Now, my lord, again, the defendant number 2 has not brought on record any evidence which would prove that CBRE was the one who provided with them the details. On the contrary, my lord, if your lordship sees the documents I have tendered in respect of the defendant number 2, my lord, our interaction started from sometimes in February 2015, 2nd or 3rd of 2015, and the first mail I received from their end was on 3rd of February
2015.
Asking me, as per discussion, if your lordship wants to take a look at it, I think I have already what I want to highlight before your lordship, my lord, the opening line of that mail is as per discussion. So there was also, but there is that amply proves that even with respect of the defendant number 2, there was an oral negotiation which was held between the plaintiff and the defendant number 2. As per our discussion, please forward. And we have forwarded. Once having forwarded the necessary documents which were required, again a mail came from their end asking me to give some further details, particulars, which was also given, admittedly received by them. Then they say that they want to come and see. On 5th, appointment fixed. They fail the time. When I tell them, look here, you any other day, since you have failed on 2 slots of time, you have failed, so I cannot accommodate you anymore because I have other commercial commitments. My lord, they stop interacting with me. And I had offered them on the very next day, and it is on record that on 6th of February, they go with CBRE. Well, they have not brought on record any document from which it would appear that it was CBRE who had given them. Your Lordship will recollect that your Lordship had put this question both through the defendant number 1 and the defendant number 2 was asked several times by your Lordship when it was submitted on behalf of the defendant number 2. I shall show it to your Lordship, but there was nothing on record to show, and that is why they failed to show. In my respectful submission, they went with CBRE on 6th. They could have easily gone with me on 6th. They deliberately avoided that. It was an ploy to avoid going to the property with me in order to portray it to the world at large that I had failed.
No, that only the main that once you have fixed the time that you could not reach, they could not reach, they subsequently wanted to
Twice.
Yes, afternoon. So
that also failed. They failed. It was they who were at fault. So they could have easily accommodated me and went on the next day, which they did with CBRE.
Yeah.
And my respectful submission is that they got the entire know-how of the property, the postal address through me.
And subsequently entered the
the defendant number 1.
You made out.
The defendant number 1 has submitted in and it has been pleaded in the written statement also that since the defendant number 2 had stepped in, I was no longer interested, so I did not take any steps. Contrary to the acts and actions which has been admitted by the defendant number 1, what was the reason for which he had asked for the postal address in January 2015? Only for the purpose of passing it on to the defendant number 2?
Yes.
And the defendant number 2 also got all the assistance and the particulars of the property from me. They have failed to put anything on record from which it would appear that CBRE was the one who gave them, but they went with CBRE, and it is as per the case made out by them. They have admitted that CBRE was the broker and CBRE was the one who got the brokerage because CBRE was their working partner.
But that is not proved.
They have said that in their
But they are not.
Nothing.
They have not produced the document
Yes.
with regard to the CBRE.
So, so far as the factual part is concerned, this is the sum and substance of what they have said and what we have pleaded and whatever is there on the records. Now, my lord, in view of the arguments made by my learned friend, my lord, on the last occasion I said there are 2 or 3 judgments which I would like to refer. On the principle, my lord, first of all, unless it is pleaded, the court cannot look into any subsequent argument or
In that case, what if you want
evidence?
If you want any further judgment to be cited other than the which you cited earlier, you want to cite, you give the copy to them so that they can get an opportunity. So
Yes,
in
my
that
lord.
reply, it is not. But if you want with
Copy
regard to
is
that,
my lord, I have copy.
give the advance copy to them so that they can give the reply to me.
But I am giving them copies. Copy লাগবে না? এটা কোনটা দিচ্ছিস? না না, I need 2018 টা দে। 11 দিয়ে লাভ নেই। 2018 আর 2016 এই দুটো হলেই হবে। আমার বইটা একটু দিন। এই দুটো। But I will cite only 2 judgments. এই চিন্তা আছে? মানে এটা না। 2018 2018 আর 16 এই দুটো দেন। Let me I handle as much as দুটো কপি দিই একটা আমি मतलब 2018 volume 11 page 362 652 my lord I would like to refer to paragraph 24 my lord. My lord, paragraph 24 is not required. 26 if your lordship takes. May I please? My lord, in the somewhere in the middle of the paragraph, it is a settled principle of law that the parties to the suit cannot travel beyond the pleadings. So also the court cannot record any findings on the issues which are not part of the pleadings. In other words, the pleadings on which the parties are contesting the case, any finding recorded on an issue dehosts the pleading is without jurisdiction. Such is the case here, my lord. So this is the principle I am relying on. Very well settled principle, my lord, that unless pleaded in the pleadings, any amount of argument or evidence cannot be looked into by the court.
Yes.
And my lord, the other judgment, 280. কপি লাগছে না এই অনুজের কপি লাগছে না তো দিদিকে আমি দুটোই আছে জজের একটা কপি One of the other judgment is 2016 volume 12 page 288 my lord. My lord, at page 294, my lord, paragraph 14. I'm relying on this paragraph. It is settled law that denial for want of knowledge is no denial at all. The execution of the sale deed was not, this is a facts of this particular case, my lord. Lordship can skip this line. The provisions contained in Order 8, Rule 5 require pleadings to be answered specifically in the written statement. This is why I, on the last occasion, I had taken your lordship through the written statement of the defendant number 1, pointing out that there is no denial. The court in the case of such and such has laid down that if a defendant has no knowledge of fact pleaded by the plaintiff, plaintiff is not tantamount to a denial of existence of fact, not even in a implied denial. Well, the next paragraph. Moreover, there was no effective cross-examination made on the plaintiff's witness in respect of the factum of the execution of sale deed. My lord, your lordship will skip this and come to paragraph 16. My lord, in such and such, it has been laid down that the matter sworn by one party in pleadings, not challenged either in pleadings or cross-examination by the other party, must be accepted as fully established.
That's why I put the question to the defendant number 2. What is the cross-examination?
Well, no questions put, no denial made. So whatever I have stated in the plaint,
What has come in the chief, it is not denied, deemed admitted.
whatever has been pleaded in the plaint.
It is in the plaint, and but if it is not pleaded and it has gone more and above the plaint and it has not been denied in the cross-examination.
Well, there is no denial in the written statement
that is
that I am not entitled to the damages I have claimed. No specific denial.
Yes.
In argument, you can say a lot of things, but where is the pleading?
Argument is based on the document.
Absolutely. On the pleading that whatever has been pleaded, and no such, the Carapiet's judgment, my lord, is a landmark judgment. Everybody knows. You have to lay down your case in suggestion. That also is missing.
Carapiet has met on the what the cross-exam, what is the effect
What
of the
is
cross-exam?
exactly? I am deeply obliged, Your Lordship.
Not
My lord,
cross-examine, and what will be the effect of non-cross-examination on the point which has brought on record?
I am deeply obliged, my lord. My lord, in my opening arguments, I had taken your lordship extensively to through the evidence, where I have established, or I have tried to establish, that the defendants, both the defendant number 1 and the defendant number 2, have failed to lay down their case by way of suggestion also. There is no suggestion. No denial in the written statement and no suggestion by way of cross-examination to make out their case.
Yes.
In the event their witness comes to the box, before that, when you're cross-examining the other side's witness, you have to lay down your case by way of suggestion, which was not done. So, my lord,
why when this amended provision has come, orders 18 rule 17, filing a examination in chief. So an initial stage of that amendment, we used to give the affidavit in terms of the plaint on.
Absolutely.
But that contains the not a fact with regard to the written
yes,
statement.
the juror position is very important.
That is, unless it is not been completed, that is deemed. Even though file the written statement, you are not taken as a not a fact in either examination chief or cross examination. It deemed.
I am deeply obliged, Your Lordship. Well, that also I have shown while I was making my arguments.
That I have taken note.
So, my lord, this is and these judgments, I am constrained to show this judgment at this later stage in reply because of the argument which came from my learned friend's side.
Okay.
It was not there. I did not have the opportunity of indicating this. But so far as the judgments cited by Mr. Ghosh and the defendant number 2, my lord, the distinguishing of those judgments, I will do it in my written notes of argument. It need not. I don't need to waste the court's time, my lord.
Notes of argument dealing with the judgments also,
yes,
so that I can.
Well, I think that completes my argument. I am deeply obliged.
Well, will my lord fix a date, my lord, for reply, or very short?
You have only 2 points.
I wanted to, my lord, just examine one factual aspect. I was not expecting my learned friend to conclude because a lot of judgments were cited, my lord. So only my lord, there is an argument advanced that there is nothing on record to suggest that CBRE had executed the transaction, my lord. I think there's one document, my lord,
My lord,
exhibited by the
at the cost of interrupting my learned friend, my lord. Today, my lord, my learned friend is in reply to reply.
No.
He can only refer to
With
the
regard to
judgments.
what the submission they have made, I have taken, this court will consider.
A lot
with
of
regard
facts have been submitted by my learned friend in reply to my reply.
No,
So I did not interrupt her.
What about your judgment? You
The
tell me?
judgments, my lord, these are my lord, very well settled principles of law. This cannot be denied that unless it is pleaded. No, I cannot comment. These are well settled principles of law, my lord. On these principles, I have no difficulty, my lord. The
Regarding
question, my lord,
whatever if it, the learned friend you
yes,
find that if she has given some other thing,
my lord,
you
on
also
these two
file-
judgments, yes. On these two judgments, I've got nothing to say because both of them are very well settled principles of law. But question is whether those are can be applied in the facts of this case has to be examined. Whether there is no denial, my learned friend has submitted, my lord, there is no denial anywhere in the pleading, nor in the suggestion, or in the cross-examination. Perhaps that's not factually correct. I cannot go into the facts again in reply to reply. I shall indicate in my note where I have said this, my
Yeah, so
lord.
you give the reply
And
to
with
all.
regard to my lord, so pleading, and with regard to the fact that my lord, the second judgment, my lord, says, my lord, paragraph 14, same on the same principle that unless it is challenged, it has to be admitted. My lord, I say it has been categorically denied in the pleadings. Fact that, my lord, I did not enter into any contract is also admitted position. It's the defendant number 2 who did entered into the contract. But these facts are well my lord, explained to my lord on series of occasions, my lord. I shall file a short
You
note
file the short note,
indicating
both the
my
parties
points of
are-
reply.
How soon? Within a
I
week?
think I'll need a couple of weeks time, my lord.
2 weeks.
2 weeks time because after vacation.
Immediately upon reopening, my lord. Your lordship keeps it for orders on one day.
I am fixing a date only for filing return notes.
Yes,
of
yes,
argument,
madam.
Nothing else.
Yes.
But regarding defendant number 2, lordship, we have already elaborately submitted.
Give the return notes.
File the written notes.
Return notes, no problem. Return notes of argument.
Written notes
Uh,
problem.
And you also got the
Feel okay,
judgment, copy of the judgment?
yes.
পারবেন
Uh,
last
so
day দিয়ে দিবি?
for the plaintiff, so-
ছুটির আগে হবে না।
How does it make it?
Reopening. I love reopening.
Huh?
In reopening, madam.
Yes, no problem.
Of course, not before you.
Hearing concluded, argument concluded. Solicitor parties are directed to file their written notes of argument by 5th of January.
Very well.
5th of January 2022. Is the matter
I'm
5th
deeply
January for filing written notes of argument by all the parties.
Same appearance. Deeply.
बारह बजे का मैटर है ना?
Valid, I'm for the
कल का देखो, कल क्या है? कल क्या है? कल फिक्स है? कोई फीड कर लेगा बात करो। Saturday, hearing 11 बजे फिक्स है। होना है, किस क्या है? But Mr. Banerjee, only you get the 5 minutes because other 12 PM matter is there. And
Oh,
you
yes.
will not finish by 5 minutes.
No, that cannot be.
It is fixed tomorrow or no?
13th, Bella. 13th.
13.
Yes, madam.
13 is fixed.
Yes, madam.
Come on, 13 now. 13 is already fixed.
For 13th, my lord, it is impossible, my lord.
Why?
Because
13 is
my lord,
already fixed.
already fixed. Ought to have taken adjournment on that day. Because,
Why?
my lord, a second appeal, my lord, before Lord Honorable Justice Rai Chaudhuri, who will be retiring, my lord, in this month. Lord, he expressing, Lord, argument, part matter, it has to be concluded on that day. That is the whole difficulty. Otherwise, my lord, I am here. Why should I not come?
No, that's correct. I am not telling that you are not coming.
No. But whenever I come, my lord, I will argue the case. Follow it.
Today, because the other matter is fixed.
No, that is right.
That also
No. I have nothing to say, my lord.
See, 14, 15, any date is there. When is, huh? Vacation. When? Third and for both. 3rd and 4th January. See your diary.
5th, my lord. Let
Third
it
and
be on
fourth.
5th.
I
5th,
am
my lord.
continue.
5th and 6th. 5th and 6th. Lord, 4th we have two. We have already fixed, my lord. 5th and 6th.
3rd and 4th.
I'm telling you, lordship.
3rd and 4th January.
In a state of
he's asking for 5th and 6th.
Now let it.
no, 6 cannot be. 6 cannot be. 3rd. 3rd can be.
And next 2 date I want to give so that you can finish it off.
Yes. 3rd can be. Then, my lord, on 8th, my lord. 3rd and 8th.
3rd and 8. 8 is on
9.
Then
10.
Then 4th. No, you are not available.
4th I shall not be, my lord.
5th.
5th also. No, 5th can be.
3rd and 5th.
3rd and 5th.
My lord, we have problem on 5th, my lord. Oh, my lord.
No, take note.
Yes,
Anybody, if you will not
I will do
there,
that.
then Mr. Chaudhary will not be there. Then only take the note. I don't think Mr. Banerjee will finish on that. Will you finish? One day you will finish.
May not be possible.
Council for
Lord,
the
if I say must be possible, then I must have to do that.
for the census suffering for the plaintiff, census suffering for the defendant. Due to the paucity of time, the matter could not be taken up for hearing. Let the matter appear on 3rd of January 2023, 2024 and 5th of January 2024 as parted matter.
Lord, 3rd and 5th.
3rd and 5th as parted.
Parted.
Yes, next. बोला लेकिन विटनेस है कुछ है विटनेस होगा तो वो नहीं होगा विटनेस नहीं होगा that's it left. Yes, witness is there.
My lord, the witness is also present over
Huh?
here. My lord, the witness is present over here, but the advocate on record is not present. My lord, due to some personal urgency, he cannot attend this court today.
I can't hear you.
My lord, due to some personal urgency,
Ah.
the advocate on record cannot attend this court today.
Ah. When he will be available?
My lord,
Witness action, why he is not present today?
my lord, due to some personal urgencies. My lord.
Personal agenda. Commercial matters. Where is your witness? Where from you are coming? From Calcutta only or outside? So appearing for the plaintiff. Who is for the defendant?
My lord, I am appearing for defendant bank. Then let it be after reopening.
So appearing for the defendant. Though the matter is fixed today for witness action and plaintiff witness is also present, but due to non-ability of the advocate on record of the plaintiff, the examination of the witness could not be started. Counsel for the plaintiff prays for adjournment. In view of the submission made by the counsel for the plaintiff, let the matter appear on. Give the date for witness action. Huh? January. Time is there. Or after.
अबे तुम्हारे देखे
4th January. 4th January, come ready for witness
Grateful,
action.
Grateful.
Not to fix other matter. Huh? 4th January, keep the witness action. Yes, call the.
Number 9. Volume 4 টা পেয়েছেন?
Should I appear for the defendant number 2 and 3?
Yeah. Anil Kumar Singh. Yeah.
Volume
Yes.
PW 1. 10 PW? Oh, 3. Sorry. আমি ভুলে গেছি। Mr. Singh,
Yes.
kindly have a look to page 1084 to 1123 of volume 4 of the judge's brief of document, part of PD 59, and tell my lord what are these document all about. 1084 to 1123.
Yes, my lord. These are documents related to the expenses incurred at site, duly signed by Deputy Project Manager, Mr. Ashok Singh.
The contents of these documents true and correct?
Yes.
Had the plaintiff received or issued these vouchers and supporting documents thereof in usual course of business?
Yes, my lord.
Have you produced the originals of these documents?
Yes, these documents in original are available and have been produced in the court.
9. Lord, I am handing over file number 9, which consists of this document. Kindly look at the documents and tell my lord as to whether
File number 9 containing the original vouchers and supporting documents handed over to the witness.
My lord, these are vouchers
Witness identified the same.
related to the expenses incurred at site, duly signed by the Deputy Project Manager.
No, you already stated this is the original.
These are the originals and supporting documents. Let it be, my lord.
This is number 9.
File number 9.
File number 9 containing original documents and vouchers marked as exhibit triple C.
এখান থেকে বলবে। Mr. Singh, kindly have a look to pages 1065 to 1083 of this volume 4. The judge's brief of document, part of PD 59. And tell my lord what are the documents of that.
Yes, my lord. These are vouchers for expenses incurred at site, duly signed by the DPM, Deputy Project Manager.
Are the contents of this document true and correct?
Yes, my lord.
Had the plaintiff issued or received this document in usual course of business?
Yes, my lord.
Have you produced the originals of these documents before this honorable court?
Yes, my lord. The original documents have been produced.
Witness shown file number 10 containing documents and supporting documents in original. Documents and supporting documents in original.
Vouchers and supporting.
Vouchers and supporting documents in order.
Yes, my lord. These are
the original documents.
original vouchers duly supported with documents. In file number 10.
File number 10 is marked exhibit DDD. DDD collective. Earlier also collectively, yeah? CCC collectively.
Mr. Singh, kindly have a look to page number 1049 to 1064 of volume number 4, part of PD 59. And tell my lord what are the documents all about.
Yes, my lord. These are vouchers for expenses incurred at site. Duly signed by the deputy project manager.
Are the contents of this document true and correct?
Yes, my lord.
Did the plaintiff issued or received these documents in usual course of business?
Yes, my lord.
Have you produced the originals of these documents?
Yes, my lord. The original documents have been produced in court.
Witness shown file number 11 consisting of the vouchers and supporting documents in original.
Yes, my lord. These are original documents. Original vouchers duly supported with documents in file number 11.
EEE collectively.
Mr. Singh, kindly have a look to page number 1016 to 1017 of volume 4, part of PD 59. And tell my lord what are these documents all about. 1016 to 1017.
Yes, my lord. These are vouchers for the expenses incurred at site, duly signed by the deputy project manager.
Are the contents true and correct?
Yes, my lord.
Had the plaintiff received or issued this document in usual course of business?
Yes, my lord.
Have you produced the documents in original before this honorable court?
Yes, the original documents have been produced in court.
Witness shown file number 12 consisting of the vouchers and supporting documents in original.
Yes, my lord. These are original vouchers supported with relevant documents.
Exhibit
in exhibit number in
Cool.
file number 12.
File number 12.
Mr. Singh, kindly come to page 1018 to 1041 of volume 4 of Judge's Brief of Document, part of PD 59. And tell my lord what are this document all about. 1018 to 1041.
Yes, my lord. These are vouchers for the expenses incurred at site, duly signed by our deputy project manager.
Are the contents of this document true and correct?
Yes, my lord.
Had the plaintiff issued or received this document in usual course of business?
Yes, my lord.
Have you produced the original of this document before this honorable court?
Yes, the original documents have been produced in court.
Witness shown file number 13 consisting of the vouchers and supporting documents in original.
Yes, my lord. These are vouchers, original vouchers, duly supported with documents in file number 13.
Collectively, huh?
So Singh, kindly have a look to pages 1042 to 1048 of the judge's brief of documents and tell my of the part of volume 4 and PD number 59 and tell my lord what are these documents all over. 1042 to 1048.
Yes, my lord. These are vouchers for the expenses incurred at site, duly signed by a deputy project manager.
Are the contents of this document true and correct?
Yes, my lord.
Did the plaintiff either receive or issued this document in usual course of business?
Yes, my lord.
Have you produced the documents in original before this honorable court?
Yes, my lord. The original documents are available and produced in court.
Witness shown file number 14 consisting of the vouchers, documents and vouchers and supporting documents in original.
Yes, my lord. These are original vouchers supported with documents in file number 14.
Volume 4
How many documents? So many.
Milad, I have I have only one volume and Milad, two files are left. Milad, I'll be requiring some time to collect those documents. That's all. I'll be done. Milad, in one day it will be. And Mr. Singh kindly comes to page 1034 to 1435 of volume 5 of Judge's Brief of Documents. 34 to 1435. 2 1435, part of volume 5 of Judge's Brief of Document, PD 59. And tell my lord what are this document all about?
Yes, my lord. These are vouchers for the expenses incurred at site, duly signed by our deputy project manager.
Are the contents of this document true and correct?
Yes, my lord.
Did the plaintiff either receive or issued this document in its usual course of business?
Yes, my lord.
Have you produced the documents in original before this honorable court?
Yes, the original documents are produced to the court.
Witness shown file number 5. 5. File number 5 consisting of the vouchers and supporting documents in original.
Yes, my lord. These are original vouchers duly supported by documents in file number 5.
Six. Volume 6. Sorry. Mr. Singh kindly comes to pages 1486 to 1518 of volume 6 of the judge's brief of document, part of PD 60, 1486 to 1518. And tell my lord, what are these document all about?
My lord, these are documents pertaining to Provident Fund paid to the concerned department. Provident Fund.
Paid to the concerned department.
No. What do you mean by concerned department?
These are challans basically. We have deposited, we have by which we have deposited the PF, Provident Fund.
Whose against whose accounts the amounts are deposited as provident fund by the plaintiff?
This is on account of Rahi Infratech Limited, the employees working under Rahi Infratech Limited.
Oh, আচ্ছা আচ্ছা। Mr. Singh, kindly look into the documents and tell my lord that who had issued these documents or the depositor's copy being the documents in support of the provident fund deposit.
Yes,
Who had issued?
this has been issued by our director, Mr. Ravi Khaitan.
RAVI. Khaitan.
Khaitan, Khaitan.
How do you identify the signature of Mr. Ravi Khaitan on these documents?
I am serving this organization and he is the director of the company. He has been signing documents in my presence.
Kindly encircle the signature of Mr. Ravi Khaitan in each and every document with red pencil. Original করে দিন। এই original। Witness shown documents in original from file number 7. File number 7.
All documents have to be inserted.
Yes, yes. Wherever do you find signature of Mr. Ravi Khaitan?
नंबर तुम देखते हो 34 और 24
Are the contents of this document true and correct?
Yes, my lord.
Were the document issued by the plaintiff in its usual course of business?
Yes. Yes, my lord.
Have you produced the documents? Have you produced the documents in original before
Yes,
this?
the documents in original is available in file number 7.
The signatures had to be exhibited separately of Ravi Khaitan.
Exhibit triple J color signature of so J by 1,
J by 2,
J by 2, J by 3, J, huh?
My lord, here the documents referred, my lord, that stated that it deposited to the Employees Provident Fund organization. But here before that, my lord, there is also another organization, Employees State Insurance Corporation. Some of the papers relates to that Employees State Insurance Corporation. And the witness has said the entire documents relates to the Provident Fund, Employees Provident Fund organization.
Cross করে নেবেন। Milad, for today, Milad, these are the files. We have 2 files left.
Extra page আছে। See the number in the corpus.
Milad, we have 2 files left. Kindly give us short time. Milad, after vacation, any date, we'll just compile and Milad, we'll end on that.
It will be over.
It will be over. From my side, it will be over.
And what state?
He has to.
State employee fund.
That witness referred only Employees Provident Fund organization. But these documents also relates to Employees State Insurance Corporation. Witness has not said so.
He has not yet left the box. I will ask him the question. Milad, I can also ask on the next day. He's making my job
No, it is exhibited. That's why he asking that. The document is exhibited.
দেখে আরেকবার বলে দিন।
একবার দেখে
বলে দিন।
My lord, I have not seen all the papers. So.
You should have.
No, actual, what is the procedure? The Employment Provident Fund officer,
Has to
State
be.
Provident Fund officer will create a account number
Right.
of the employees with the details they are
Details.
having, and the amount
It
is
will be
to
deposited by
deducted
the employer.
first within the second week of the every month, and needs to be
Absolutely.
deposited. It will
Those
go
are the
more than
depositor's copy.
It will go more than the 15 days, then the compensation
Compensation and
and
penalty
the
all those.
interest is to be awarded. That
Those
is
are the
provision.
depositors.
Whether that has been amended or not, I don't know.
But the witness never said that
you said.
deposited the Employees State Insurance Corporation.
বলে দিন।
And documents relates to this, my lord. I would like to
Witness volunteers করে দিন।
Witness volunteers.
My lord, should I count the papers and tell?
No.
Whatever thing is like the way you
What you want to say?
There are two bunch of papers in this file.
Yes, say that.
One is related to the Employees State.
আস্তে আস্তে।
There are two files,
Two
bunch of
different vouchers. Chalans,
two different sets of the documents, out of which one is of
Employees State Insurance Corporation.
Employees State Insurance Corporation, and
the second bunch of document is for Employees Provident Fund organization.
Okay. Bracket close. How much time you will take further?
1 day.
1 day means 1 hour.
Half an hour.
Half an hour it will be completed.
Half an hour any day.
So after this exhibiting, your chief will be complete.
Complete.
Then your proceedings.
And then Milad for arguments. There are no more witness.
Yes.
Yes.
They will adduce the evidence. They might have some document or notice and whatever it may be.
Witness may step down.
Thank
you. Examination chief of the plaintiff witness resumed today. And during his evidence, exhibit E starts from exhibit triple C to triple J, where signature of JJ12 counsel for the plaintiff raised for time. Accordingly, examination in chief of the plaintiff witness is deferred. Let the matter appear on. Give the date. At the commercial. 11 January.
Can it be on 9th subject to correction?
9th other matter is there, I think.
If it's number 1, anyway it will be called. If it's if consider number 1,
Okay, 9 January.
like it was day before yesterday.
9 January for further examination in chief of the plaintiff.
এক number করে দেবেন।
Time is fixed, Lord, at 12.
No,
12 noon.
it is a commercial, it will take on
It will be
first matter.
taken.
Before
Very
that.
এক number করে
As
দেবেন।
your lordship.
এক number ছিল পরশুদিন।
Grateful.
Let it be number 1, on that day so that it can be called. Because if 11 a.m. it's fixed, then
11 a.m. is fixed. So that is let it be fixed at 11.
তাহলে 11টা করে দিন না।
Yes, my lord. That will be better, my lord.
When? So that is the problem. Why you have fixed the 9? Why? How? Who is the arbitrator? That's why. If you fix the other, give the other matter. Give the other, that it will take time. So there are no other matters. Okay. 9th will come.
9th, 11 a.m. my lord.
11. Not 11 a.m. And it will be in the list. Only one matter is there in the commercial. After finishing that, I will start.
Good.
So that's why I am not fixing the time.
My lord.
Very good.
Sir, just only 5 minutes, sir. No, I'm taking the password only for 5 minutes because
Password.
petitioner's advocates just now coming.
Why to be mentioned?
Today, sir. Today. Today, 5 minutes.
Password.
You appear for the plaintiff.
My lord,
On the previous occasion, my lord,
in this matter, my lord, I am appealing on behalf of defendant number 2 to 8 and 12, my lord.
my lord, on the previous occasion, my lord had directed me to file an application for the appointment of a commissioner. My lord, for the completion of the partition, my lord. My lord, there is one issue that
My lord,
needs to
kindly
be
be
solved, my lord.
allow the GA 9 of 2021, my lord.
What is the GA 9?
My lord, previously your lordship directed to distribute the amount, my lord, but still now it has not been distributed, my lord. So kindly allow GA 9 of 2021, my lord.
My lord, before that is allowed, my lord, if I may just make one submission, my lord. My lord, the application for the commission, my lord, the commissioner I shall make within the course of this week, my lord.
Huh?
Within the course of this week, my lord. However, my lord, the plaintiff, my lord, does not have the funds to pay for a remuneration for the commissioner. My lord, if that may be given from the joint account that is maintained, my lord, as of today, my lord, that is part of the GA 9 as well.
GA 9 is for distribution of money.
My lord.
Where is the application for appointment of commissioner?
My lord, that has not been filed yet, my lord.
Not filed.
No, my lord.
Oh, there is an order. Taking steps for appointment of partition commissioner to the effect of partition so and so, in where the commission let the matter appear. If the plaintiff files an application,
Yes.
they will not file the application.
No, my lord.
So what can
My
be
lord,
done?
I shall file this application within the course of this week, my lord. My lord, that is the only submission that I have to make. My lord, the application I shall file within the course of the week. If my lord directs for an order allowing the bank account to be used for the remuneration of the commissioner, my lord.
How many parties are there?
My lord, the plaintiff and
How many parties? Plaintiff is 1.
yes,
12.
1A, 1B. Original plaintiff died.
yes, ma'am.
And with regard to the defendants, how many defendants? 12. 12 are there, out of which 7 expired, 7 have been Substituted. So all the defendants are appearing.
2 to 8.
You are appearing
We are for 2 to 8 and 12.
2 to 8 and 12. So what about the 1, 9, 10, 11? Who is appearing? Nobody is appearing.
My lord, not to my knowledge, my lord.
Huh?
My lord, I am not particularly aware.
8 and 12. Last occasion also the same thing was happened. So how much amount is pending? Where the amount is there? Where is the amount in the bank?
No, in the custody of the my lord, plenty, my lord.
Plenty.
My lord,
Plenty, my lord.
it is in the custody of a bank account, my lord, that has been maintained in the affidavit in opposition in GA29, my lord.
Here 9 you filed a affidavit in opposition.
Yes, my lord.
You have disclosed.
My lord, that is my instruction, my lord.
You have not gone through.
My lord, till today no application has been filed.
What is the amount which you are having? Rent.
My lord, I do not have the instruction on this, my lord.
You are appearing, you know, instruction. What amount he is having?
8 lakh something, my lord. 8 lakh something.
No, what? For what? He has taken the rent from the tenants. How he got the amount?
Rent from the tenant, my lord.
That's why I'm asking. So in that case, what if he file an application for commissioner, I will appoint a commissioner. Let the commissioner take all the accounts from him and open. You are not open the bank account.
My lord,
How the amount is pending in cash with you?
No, my lord, they are part of the joint accounts. My lord, these are maintained
account?
jointly. My lord, these are maintained jointly. My lord, these are the subject matter of GA numbers 9.
So
Of
that's
GA
why I'm
number.
asking joint in the name of plaintiff and the defendant.
Yes,
all.
my lord.
In all's name.
My lord, perhaps, my lord, I'll need to take instruction on that, my lord.
So if it is not, then you come with the clear picture of both the parties. Nobody is knowing anything about that.
Yes, my lord.
If then a commissioner will be appointed, then all the amount is to be given to the commissioner, and the commissioner will keep in the fixed deposit on some amount. What about the amount that he will? What about the further? You're not collecting the rent.
My lord, this is.
How many tenants are there? Nobody is knowing anything. Appearing before the court.
My lord, if my lord adjourns this for a week, my lord, that application, my lord, I shall file for the appointment of a commissioner.
Sons. What is your good name?
My lord, Shayuk Mitra.
Sons appearing for the plaintiff. Sons appearing for the defendant number 228, 228, and 12. None appears on behalf of other defendants. Full stop. Counsel for the defendant number 228 and 12, pressing for hearing of hearing of GA9 of 2021. Counsel for the plaintiff, press for time for taking appropriate steps for filing an application for appointment of commissioner. Consider the submission made by the counsel for the respective parties. This court find that the application, this court find that one further opportunity should be given to the plaintiff for filing an application for appointment of commissioner. Let said application be filed within a week from date. Is the matter on 20th December 2023. It is made clear that on the date fix, if no application is filed for appointment of commissioner, the application filed by the defendants being GA9 of 2021 shall be taken over here.
My lord, 20.
They will not find, yes, 20th December.
20th December. Marvelous election.
Yes. Next.
So this is my application as plaintiff for amendment.
I appear for the substitute defendant number 1A, 1B, and 1C.
Well, Lord, I believe
I appear for defendant number 2 and 3.
Only defendant number 2 and 3 against them. This application for amendment is being made. Lord. Paragraph 19.
Which application? Application number? GA number?
GA number 4. In earlier, GA number 5 has been allowed and substitution has been effected.
Yes, substitution has been allowed.
Defendant number
that
1.
Amendment has been carried out?
Yes. Carried out. Carried out and the service has been effected.
So what is the amendment now?
this is a very minor amendment, my lord. This is a suit, my lord, where, my lord, a gift deed is sought to be, my lord, by my client is gift deed is sought to be projected and declaration and injunction sought for. Basically, because, my lord, it was sought for that
Declaration for absolute honor.
injunctions are necessary for the prevention.
Where is the amendment?
Amendment? Well, the amended portion is at paragraph 19. Lord, that is, Lord, the earlier it was said to be that there is no claim sought for against the defendant number 2 and 3. Because the defendant number 2 and 3, I am not seeking any relief of injunction. But so far the prayer A is concerned, my lord, I am seeking the relief against all the other persons. Let me defendant number 1.
So you wanted to delete the original 19 and add the new 19.
Only 19.
That is one.
19 with the red.
So earlier there was a 19, you wanted to delete that portion and add a new one.
That 19 is at page number 13 of that particular page.
So you want that.
And, my lord, only relief, there is only relief that, so far the declaration is concerned, everybody is bound by declaration. And declaration, I have sought for, I am not challenging, I am not claiming any change of the declaration term.
So there is no prayer, there is no amendment.
Prayer A is retaining.
So there is no amendment in the
No,
prayer.
no prayer.
Only
with regard to that the declaration is sought for.
Who is for the defendant number 2?
Defendant number 2 and 3 immediately was there.
Yes, you any objection?
Well, he cannot possibly have any objection because she is appearing for defendant number 1A, 1B, and 1. They are not affected.
20. So appearing for the plaintiff. So appearing for the defendant number 1A and 1B. And so appearing for the defendant number 2 and 3. The plaintiff has filed the present application being GA4 of 2023, praying for amendment in the plaint by deleting the original paragraph 19 and incorporate the new paragraph 19 as appearing in the proposed amendment at paragraph 12, page 12 and page 13 of the print. Consider the submission made by the counsel for the defendants. There is no objection for allowing the amendment as prayed for by the plaintiff. Consider the submission made by the counsel for the plaintiff and counsel for the respective parties. Produce the proposed amendment. This court finds that if the said amendment is allowed, none of the party will be prejudiced and nature and character of the suit will not be disturbed, will not be changed. Consider the submission made in view of the above prayer.
Please.
A to F of the master summon is allowed. GA4 of 2023 is disposed of.
Extremely grateful. Extremely.
Much of that.
I appear for the plaintiff in this matter.
Lord, I appear on behalf of defendant number 4 and 5, Lordship, virtually.
Well, if your Lordship recalls, my learned friend for the who appears for the defendant number 1, 2, and probably 3, when I had indicated that the defendant number 1 has now changed from a partnership concern to a proprietorship concern, and defendant numbers 2 and 3 have merged into a separate entity called Orient Beverages, my lord. So far as the document regarding defendant number 1 from partnership to proprietorship, my lord, they have served, my lord. Regarding defendant numbers 2 and 3 to a separate entity, they have furnished a document, my lord, but it appears that the defendant number 3 has merged. The document regarding defendant number 2 has probably not been given, my lord. I have explained to my learned friend also. My
Lord,
humble submission is that, my lord,
whatever we have with us, my lord, that has been given by way of a covering letter dated 11/10/2023. Now, my lord, I understand my learned friend is having some difficulty in finding out, my lord, the relevant order by which, my lord, the defendant number 2 has been merged with a separate entity. Now, be that as it may, my lord, whatever documents we had supplied, my lord. We have given them a covering letter by which we say on oath, my lord, that this particular, my lord, defendant has been merged with a separate entity. This is, my lord, the letter, my lord, by
this is the
which.
covering letter, my
So what you will do?
lord. I was humbly
And, my
submitting,
lord,
my
your
lord.
lordship
We'll
has
sort
also
this out
recorded,
between
my lord,
ourselves.
our submissions that it has been, my lord, merged with a separate entity. That is recorded
That's
in.
the submission which they have recorded, my lord. Well, I'm saying, my lord, only humbly submitting. Your lordship kindly takes it up, keeps this matter in January, my lord. In the meantime, I'll sort this out between my learned
Because
friends.
if your lordship recalls, my lord, I had categorically, my lord, submitted before your lordship, my lord, until and unless, my lord, they take steps, my lord. I cannot file, my lord, my written statement because application cannot be, my lord, affirmed.
Lord, there has to be one document to the effect, my lord. My learned friend's submission that they have changed will not suffice. Different number,
My lord, every document your lordship recalls, my lord,
that is pertaining to
the
different number
articles
3, my
of
lord.
association is there, my lord.
Articles
My lord,
of
I
association
understand my learned
served
friend is
upon my
having
lord.
a difficulty, but we have written them on 11/10. And today is, my lord, December.
Why you have not asked for the
My lord, that is
document?
because of my personal difficulty, my lord. I could not. I was not in court, my lord. I could not attend, my lord. That is the difficulty, my lord. And my lord, have submitting kindly keeps it in the month of
My lord,
January.
whatever documents we had, my lord, we have supplied.
Yes, you
Let them take steps, my lord.
This is the document, my lord, which pertains to different number 3. So far as the different number 2 is concerned, my lord, nothing is there.
What about the 2?
There
My
has
lord,
to be an order of the High Court.
There, my lord, my client has made an endeavor, my lord, to find out whether there is any document or not regarding to. But since it was been merged, my lord, long back, my lord, no documents could be traced out. So thereafter, my lord, we have written them, my lord. On by way of this covering letter, your lordship has recorded, my lord, our submission.
The date of merger has not been given, my lord. There has to be the order.
Doesn't matter at all. We say that it has been merged long back. That is recorded.
Merged with whom?
With the Orient Beverage.
A separate entity, my lord.
So you take that if it is merged with the...
Because ultimately Orient Beverage is coming into the picture because the old defendant number 2 and 3 has merged with Orient.
only Orient. So you file an application but delete and Orient may be added. That's all. As per their submission,
That case, my lord, kindly keeps it in the month of January, my lord. I will take steps in the meantime.
Sons appearing for the plaintiff. Sons appearing for the defendant number 1, 2, and 3. Mr. U.S. Menon and advocate appearing for the defendant number 4 and 5 through virtual mode. By communication dated 11th October 2023, the counsel for the defendant number has informed with regard to the merger of defendant number 2 and 3. But the counsel for the plaintiff for some time to take appropriate steps and wait for time. In view of the submission made by the counsel for the plaintiff, let the matter appear on 8th of January 2023. In the meantime, the plaintiff is directed to take appropriate steps.
Lord, may I take back the copy of the letter? If your lordship requests, my lord, I shall furnish a photocopy.
Next time we'll see.
Grateful.
Grateful.
Sorry.
Lodge.
Thank you, my lord. On the last occasion when this appeared, my lord, I requested your lordship to transfer this to the commercial division. It's a commercial dispute altogether. Your lordship had seen it on the earlier occasion. My learned friend was opposing at that point of time, saying that he has an application under Order 7, Rule 11. But I said that first it should be transferred, then it should be heard, or else your lordship's order would be a nullity otherwise. But today I believe, my lord, he concedes and it should be transferred to the commercial division.
Your Lordship, we
So,
consider.
my lord, good sense prevails. So, my lord, I was only submitting, my lord, directs the department to take necessary steps. And my lord, after that,
You also to take
yes,
steps.
obviously, my lord, department along with the
Both parties.
both parties to take necessary steps.
As per the
And my lord, I'll be arguing before your lordship, there's that point pending, my lord, because I want to argue.
then I am also.
Yes, my lord, because well, we need to be careful. But there I have a strange feeling, my lord, we needn't do much. So if we don't do much, then things will be, my lord, here is a case of substantial justice which is being prevented, my lord.
That's
So
why
I will argue that
to,
there, my lord.
That's why I wanted to hear and come.
Yes, well, I'll argue them. But my lord, let both the parties take necessary steps. And
Because why I'm telling,
my lord,
in that case, the other parties know the faith.
that is the point. That is the point. My lord. That is why, my lord, I say substantial justice, my lord, requires to be done here. So that is why I think that section might be read down a bit, my lord. My lord, can we come back after the vacations when they have their application order 7 rule 11? So that is, I don't know whether you're not.
2 weeks time to complete the
Yes,
provisions of the Commercial Code Act.
My lord, and let it
In the
then
meantime,
come.
you do all these things: statement of truth, affidavit of documents, and list of documents by way of an affidavit. Exchange that.
In
And
2 weeks,
file
let
that.
it come back.
Thereafter, I will take
Yes.
their application.
Yes, my lord.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the respective parties submit that the nature of the suit is of commercial in nature and is required to be transferred from this court to the commercial division. Consider the submission made by the counsel for the respective parties, peruse the plaint and the document. This court find that the suit filed by the plaintiff is commercial in nature and required to be transferred from this court to commercial division. Accordingly, CS number 249 of 2015 is transferred from this court to commercial division. Counsel for the plaintiff and the defendants are directed to comply with the provisions of the Commercial Code Act within a period of 2 weeks from date. Let the matter appear on 9th of January.
Very good,
Before the commercial division, along with all connected applications.
Very good.
Lordship, I am for the plaintiff in this matter. On the previous occasion, Lordship was pleased to appoint a special officer and had directed us to make the payment of his remuneration. We have made payments to them. In the meantime, the respondents have preferred an appeal against the order of appointing a special officer. There is no stay. There were directions of filing affidavits, which we have done. The returnable date is on the 13th of this month.
The premises number 33 of the Lenin Sorony, my lord. There is, my lord, in the first floor, one, my lord, Balmiki is the totally unauthorized occupant. And another, my lord, the occupant, he is nothing but a hooligan and forcefully, my lord, enter into the room, one room. And another Balmiki.
Have you submitted the report?
Lordship.
Have you submitted?
I have submitted the earlier occasion. Page number 3 that I have narrated it.
It has been circulated to all the parties.
Yes, Lordship.
Yes,
so you want to take exception? What about you?
Lordship kindly gives us some time because we have already filed an appeal, the Lordship, which is pending and it is due to come up.
Yes. Both parties have filed an appeal.
No, we have filed.
They have preferred an appeal.
You are for the defendant.
I am for the plaintiff in this.
Defendants are preferred.
Defendant has preferred.
My lord, collection the my lord occupation, sir. My lord, perhaps they need to the police assistance.
Okay, let us see. If
They have threatening. They have threatening the first floor of 33 Lenin Sorony. The two unauthorized occupants are threatening me.
Okay, if you then you file the report, then I will see to that. With regard to the threatening, you file the report, then I will see if they, in the meantime they have preferred an appeal. If the appeal is okay, if it is set aside,
I have already been filed, my lord.
I will see to that. Let the appeal be disposed
And
of.
place number 3, I have narrated it.
Consensus appearing for the plaintiff, consensus appearing for the defendant. The learned commissioner appointed by this court is also present in person. It is informed to this court that the defendant number.
The
Defendant has preferred an appeal before against the order passed by this court, and the same is pending for adjudication. Counsel for the defendant prays for time. In view of the submission made by the counsel for the defendant, the case adjourned for 2 weeks. Let the matter appear on 5th of January.
I'm good.
Yes, you are appearing?
No.
None appears on behalf of the petitioner. No accommodation is sought for. For the interest of justice, the case adjourned. Let the matter appear on 10th January 2024. It is made clear that on the date fixed, if the petitioner will not appear and will not take any steps, appropriate order will be passed.
I am appearing on behalf of the petitioner. On 12th of October, my lord, your lordship's pleasure was to pass an order directing us to make an amendment. Immediately thereafter, my lord, we had applied for the certified copy of the original application. It is still not available because the file is lying before your lordship, my lord. Subject to your lordship's approval, my lord.
Copying section has not given the requisition for sending the record to the copying section?
Probably not.
So?
Or even if they have given, my lord, since the files are lying before this honorable court, my lord.
So what is your prayer?
My lord?
What is your prayer?
For grant of probate. Uncontested.
Without the amendment?
No. My prayer is that, my lord, your lordship.
What for amendment? Why the amendment is required?
There were some mistakes. On the last occasions, my lord, you.
So what you pray now? What you want now?
I want to get my application amended.
So where is your amendment application?
It is not there because the certified copy of the original application.
So that's why what is your prayer?
My lord, I was praying that your lordship may kindly direct the matter to go out of the list for the time being. And your lordship may kindly further direct that the file be sent to the department so that the certified copy be made available to us. Thereafter, my lord, we shall make the application for amendment and take out a
Constitutions appearing for the petitioner. The counsel for the petitioner submits that the petitioner has supplied for the certified copy of PLA number 209 of 2019, but the record of PLA number 209 of 2013 is lying before this court, due to which this could not get the certified copy. In view of the submission made by the counsel for the petitioner, let the record of PLA number 209 of 2019 be sent to the department so as to enable the petitioner to obtain certified copy of PLA number 209 of 2019. Let the matter appear on 16th of January 2020.
Your Lordship, I appear for the plaintiff in this matter. Your Lordship, this matter is appearing at my instance. Your Lordship, I was kindly praying for withdrawal of this suit, Your Lordship, as the parties has amicably settled the matter outside the court, Your Lordship.
Have you written instruction?
Your Lordship, I have the authorized person.
Who is he?
Sir, I am the authorized representative of Haridarshan Sales Private Limited.
You are?
authorized representative of the company, plaintiff company.
So and so appearing for the plaintiff, along with the authorized representative of the plaintiff company. On instruction of the authorized representative of the plaintiff company, the learned counsel for the plaintiff submit that the matter has been settled between the parties and the plaintiff do not intend to proceed with the suit further and prayed for withdrawal of the suit. This court heard the legal representative of the plaintiff company in person, and after hearing the counsel for the plaintiff as well as the representative of the plaintiff, CS number 47 of 2020 is dismissed as withdrawn.
Obliged, Your Lordship.
None appears on behalf of the petitioner. Let the matter appear on 10th January 2024. Huh? For what? Make it noted. That is the report. If they visited, they could have been submitted the report to me. Where is the report? Not today.
My lord, I appear for the plaintiff, my lord. It has come up at my instance for certain corrections and a clarification, my lord. My lord, if your lordship kindly takes up the order dated, judgment dated 26th of July 2023, passed by your lordship, my lord. There are two corrections, my lord, which I pay for.
July 2023.
My lord, we mentioned it the matter earlier also, my lord.
No, that too, you mentioned the matter on the same day, on the same thing was.
No, no, my lord. Unless and until we obtained the copy of the same, so we could not locate it.
Why
Detect it, my lord.
what is available in the website?
My lord, after we got it from the website, we indicated, my lord, there is another
Website
aspect.
on the very second day of the judgment, it is available. Why you not
My lord, we mentioned it, my lord. Thereafter, it didn't come, my lord.
mention?
That I have to check up, my lord. We mentioned
Where is,
twice.
what is the correction?
Yes, my lord. My lord, first is the name, my lord. It's written first page, my lord. Moinak Das. It should be Manik Das, MANIK. And the next, my lord, is here, my lord. It's at page 7 of the order. Page 7, my lord. Paragraph 18, my lord. Last three lines, my lord. Paragraph 18, the receiver shall not disturb the possession of the defendant number 1, in which the defendant number 1, along with his family members, are occupying for their own use. My lord, it's not the dwelling house of any of the parties to the suit. It's under his possession, certain portions under possession as per the receiver's report, but not as a dwelling house. It's not a dwelling house of any of the parties.
But he has in the map watch at the
No,
time.
my lord, kindly see, my lord. Not the dwelling house, my lord. There are several tenants, my lord, who are residing there, but it's not the dwelling house of any of the parties to the suit. We have specifically also stated that my lord, if your lordship kindly takes up the cost title also, my lord.
No, he has submitted some map and all these things.
Map, my lord.
Where is that report? My lord. This is part in the GA.
Yes, my lord. GA5, my lord.
GA5. GA5 record is not
GA5,
here.
my lord. It starts at page 96. Page 96, my lord. and দাও কত দিলাম তোমারটা দাও না আমারটা তো দুটো হলো তিনটে বলো volume 2 ওটা দরকার নেই রিপোর্ট ইজ হিয়ার দ্যাটস দ্য থিং আমাদের দুটো ভলিউম ওদের তিনটে ভলিউম G5 my lord if your lordship kindly takes up page 114 of GA5 my lord of the petition my lord of the application GA5 the table given my lord showing it did not say it is for the dwelling purpose and it's also not the case either of the plaintiff or the also not the case either of the plaintiff or the defendant.
114.
Page 114 my lord kindly see this is the table given my lord plaintiff has nothing in his possession defendant number 1 my lord he has in his possession my lord it's written entire scheduled suit property 7 except the tenants and occupiers portion.
Correct.
Yes my lord it's not for the dwelling purpose it's not written anywhere that he is dwelling he's using it for dwelling purpose with his family my lord.
Lordship, page 117, paragraph 8, the receiver has specifically stated that I find that the entire scheduled property has been under the possession of defendant number 1.
No, it's
And
not.
we are not dwelling in the house because it is not in habitable condition.
No, my lord, they didn't seek for any clarification
It is
today.
reflecting in paragraph 9.
No, what the
My
receiver
clarification
cannot
was
disturb the person or defendant in the defendant along with his family members.
that
are
part
occupied.
only my lord that phrase my lord only
Come with
that
an
part.
application for it is not the correction.
No my lord it's
Come with an application.
no my lord it's along with his family members are occupying for that your lordship was
Come with an application, serve the copy, review or modification.
my lord it can be done.
This is not the clerical error, sir. This is a fact.
No my lord fact
This is the facts which the court is. You are telling that the fact is not correct.
my lord
Whether
it's,
it is a
my lord
clerical
the
error.
defendant is here my lord kindly ask the defendant for a moment.
Petitioner and the matter is listed as to be mentioned.
My lord, I appear for the defendant number 2 and the legal heirs, my lord.
Order dated correction of the judgment or order of the judgment dated 26 July 2023. But after hearing the counsel for the you are for the plaintiff.
I am for the plaintiff my lord when the first one is that can be
this court find that the correction which the plaintiff requests is not a clerical error. It is a fact which cannot be corrected on verbal service.
my lord one more thing my lord for which I am before your lordship it's a clarification of the order my lord why my lord kindly see the next paragraph 20.
That's why if you want any clarification, come with an
No, my lord,
application. This is not a correction.
my lord, why
sir.
the
You
problem
are
is
senior
I will
lawyer.
definitely my lord I will definitely come for the correction it's
Ah.
not for the correction my lord. Kindly see page 20 paragraph 20.
To July 5 after 5 months I will not touch.
No my lord we mentioned
Sorry,
my lord
I will
kindly
not.
see.
I will
Lordship,
not
this was mentioned after
It is
the
not that the
first
court is
sitting
not
with the receiver. After the first sitting with the receiver,
my
it
lord,
has been
kindly-
mentioned.
No, my,
Earlier you are not appeared. Some other advocate is
no,
appeared.
my lord,
you have
kindly see
given
paragraph
left and right,
21.
then you are appearing
I will
before
not
this
disturb
court.
your lordship. Take your lordship's
Come
valuable
with an
time.
application.
No, my lord, what happened, my lord?
Just call the next matter.
My lord, kindly, my lord, for a minute, my lord. My lord, they are not paying the remuneration as fixed by your lordship.
Let the commissioner come, whatever is.
Now, they are saying that it's not 1/3 as your lordship has not directed. It's not written.
Where I know. The application 34. Number 1 is
Item number 3, my lord, I am being one of the beneficiary, my lord. We have taken out an application, and in that application, your lordship passed an order appointing the administrator in Pendentolite with a direction upon her to intimate the erstwhile executives to hand over all the documents, my lord. My lord, initially she was unresponsive, my lord, but recently I have under a covering letter of learned administrator, it came to our knowledge that she contacted her, my lord, and handed over few documents, my lord, but not all the documents, my lord. The documents which we are requiring, my lord, the details of the bank accounts of the testatrix, my lord, which are lying, my lord, in different banks, my lord, and
Who are
LIC.
you?
I am one of the beneficiaries named in the will, my lord.
Why the case is going on? What is the stage of the case?
My lord, initially what has happened, my lord, my lord, we have
Charge of the executrix.
my lord.
I am the executive, my lord.
Administrator.
I am the administrator.
Kamala
Kamala Pushparathan Pillai is an executive.
You are
My lord, she was removed, my lord. What has happened, if I may be allowed to narrate, my lord? My lord, initially, after the filing of this PLA application, it came to our knowledge, this PLA application was filed only by the executives. Thereafter, we came to know about the existence of another succession case which was going on before the Alipur judges court, my lord. District judge was about to pass the order when we appeared, my lord, and they chose not to appear before the court. In their succession case, my lord, they have disclosed several accounts which has not been disclosed in this instant application, my lord. Thereafter, we took out an application before your lordship, seeking an order for removal of the executrix, my lord, and subsequent handing over all the documents which are lying in her custody, my lord. My lord was pleased to allow our application, my lord. Executrix was removed, my lord, and the administrator was appointed in the matter. Thereafter, the learned administrator causes several letters addressing the erstwhile executrix to hand over. She was unresponsive for a considerable period of time, but from the letter of the learned administrator, it transpired that by a letter dated 1st of December, my lord, she had sent some documents to the learned administrator, thereafter stating that she is paralyzed and everything. But the documents relating to the bank accounts and LIC policies has not been sent, my lord. That is the current status of the.
Yes.
Yes, my lord, I'm contacted with her before 20 days before. Rajkumar Shah is a beneficiary. Give me that one number, mobile number, and then I will call her. The previous executives, Kamala Pushparathan Pillai, then discuss with her with telephone. But after that, she sent me some document, few documents by WhatsApp. Then I print out these some documents, which I can submit before this. But she did not submit any bank details, LIC, everything.
Okay, you file the affidavit, you file the report.
One report has
already submitted.
Further document which you have received, na?
Yes.
Earlier you filed the report.
Yes.
That is on record.
Yes.
Subsequent again you have received some document.
And by WhatsApp, mail.
And which have not been received, you file a detailed report.
Yes.
Correct. You file a detailed report, I will take cognizance on that and I'll pass a prepared order.
Yes. But my lord,
Yes.
My lord.
Yes, what do you want to say?
But she still didn't mean without supplying me any bank
That's
details.
why what the document you received, what you have not received, whether she is contacting with you, she are not supplying with you, give out report, detailed report to me. Okay. Unless and until it will not come on black and white, how the court can act?
Yes.
Correct.
Yes.
So appearing for the petitioner and Miss Mitha Ghosh Das, Mrs. Mitha Ghosh Das, and Administrator Pendant Light is present in person. Administrator Pendant Light submits that the executrix has supplied some of the document but has not supplied The bank account and other details.
Yes, but she supply me only by WhatsApp. I only print out.
The details. And wait for time to file a detailed report in view of the submission made by the administrative dependent, right? The case adjourned. How soon you file the affidavit? File your report.
Within 15 days.
2 weeks time. Let the matter appear on 3rd January.
Yes, it must be done.
Next.
Much obliged.
None appears on behalf of either of the parties. The matter was listed on 16 November 2023, but none appears on behalf of either of the parties. But with some direction, the case adjourned today. Today also, when the matter is called, none appears on behalf of either of the parties. No accommodation is sought for. Accordingly, CS number 208 of 2010 is dismissed for default. Interim order, if any, stand vacated. The matter was listed on 22nd November 2023. None appeared on behalf of either of the parties. Accordingly, for the interest of justice, the case is adjourned today. Today also, when the matter is called, none appears on behalf of either of the parties. No accommodation is sought for. Accordingly, CS number 1 of 2011 is dismissed for default. Interim order, if any, stand vacated. Same order. Dismissed. Same order as 16. Huh? Pending application are also dismissed for default. Same, dismissed. Next. Call. I will finish it. It is fixed 19 December. It is fixed on 19 December.
Lordship, I'm appearing on behalf of the plaintiff.
Yes.
None of the parties were appearing.
For the
plaintiff. I have applied towards the registrar for obtaining a certificate for and listing it as an undefended suit. Your Lordship, kindly.
But you are also not appearing.
No, on the last occasion I was not there. Lordship, I have been informed. I have instructions to appear today. Lordship will kindly keep it up to some time. I have applied before the registrar to obtain a certificate.
For the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff prays for 2 weeks time. Let the matter appear on 4th January. 4th January.
No, I am waiting for the registrar certification.
Okay,
you can Your Lordship. I am also appearing on behalf of the plaintiff in this matter.
Same.
No, Your Lordship. This is a company has gone into liquidations. I have to take steps as per law. If my instructions are keep it after in the month of January, I'll come before Your Lordship.
As per the prayer made by the counsel for the plaintiff, let the matter appear on 17th January 2024.
Grateful.
14, no? All query. Okay.
টু থ্রি আর 345 আছে ফিক্স। না না বলছি ফিক্স কি কি আছে 2 3 345।
ডিসেম্বরে একটা অর্ডার পাস হয়েছিল পিএলএ ম্যাটারে। হ্যাঁ হ্যাঁ You tell me, you tell me, I will.
তারপর আমাদের
You tell me, I will.
Yes. I solemnly affirm that whatever I depose by way of evidence in the suit, I will speak the truth. No part of it shall be false, and I shall not conceal anything. Krishna Kumar Biyani. Biyani, Biyani. Late BC Biyani. BC 72 service. Still service. Address, I'm working for Turner Motors Limited, 6 Lawrence Range. Flat 11C, Block B, Ideal Heights, 302, APC Road, Calcutta 7,09,000.
Mr. Biani, kindly tell my lord, how are you associated with the plaintiff company?
I was associated with Plaintiff Company.
Slowly बोलेगा, the recording officer is speaking.
I was associated with the Plaintiff Company as as Vice President and Company Secretary.
And Company Secretary.
I joined in 1981 and left the company in 1996.
What was your scope of duty when you were associated with the plaintiff company?
I was looking after company law, secretarial matter, company law, secretarial matter,
Secretarial matter.
legal matters, as well as administrative assignments.
When you were part of the plaintiff company, kindly tell my lord, to whom were you supposed to report in the course of your handling the legal matters of the company as you have deposed?
I was reporting to Mr. Atmaram Saravgi,
Because after the commercial code.
the managing director of the company.
Kindly tell my lord, how is the plaintiff company connected with the suit premises, which is flat number 16 in the second floor at Park Mansion, Park Street, Kolkata 7,17,000.
Plaintiff company was licensee of Graham Trading Company India Limited, of Graham Trading Company Limited, in respect of the suit premises.
I'm showing you I'm showing you a document which is marked as PD1 in the judge's brief of document. And kindly tell my lord, what is this document?
This is a letter dated 24th May 1984, written by Graham Trading Company India Limited, addressed to Salimar Tar Products 1935 Limited, Salimar Tar, Tar Products 1935 in bracket Limited, regarding granting of license in respect of fruit premises with effect from 1st June 1984 at a monthly rent of rupees 460 per month.
Who has signed this document dated May 24, 1984?
Resident Director Mr. S. Ananthanarayan of Graham Trading Company India Limited. Director only.
Are the contents of this document true and
yes, my lord,
correct?
Original?
No, this is a carbon
Office copy?
Carbon copy or office copy. It's an old document. That time of time, I think. Nowadays we don't know what is that. We used to use carbon paper earlier. May it be marked as exhibit. This is one, my lord. A. Mr. Excellent. Mr. Biani, kindly tell my lord, what is the relationship between Shalimar Tar Products Limited and Graham's Trading Company India Limited?
Both are group companies and subsidiary of Turner Morrison Limited. Both are group company and subsidiary of Turner Morrison Limited. Turner Morrison Limited.
Turner Morrison Limited.
I'm showing you the copy of the plaint and kindly tell my lord whether Shalimar Tar Products 1935 Limited and Graham's Trading Company India Limited are parties in the suit or not?
Yes, they are parties in the suit.
Kindly be specific and kindly apprise my lord. What?
STP Shalimar Tar Products STP, the name changed to STP Limited.
Shalimar Tar Product name changed to STP Limited.
STP Limited is the plaintiff herein in the suit proceeding, and Graham Trading Company India Limited is number 3 defendant.
What is the area of the flat in question at Park Mansion? Kindly tell my lord.
It is 2,800 square feet flat premises.
I am showing you a document which is PD2 in the judge's brief of document. Kindly tell my lord, what is this document about?
This is a letter dated May 24, 1984, written by myself, addressed to Sri N.S. Hoon,
N stop, S stop.
N full stop, S full stop, own, H
H
double O N, own.
Own. Regarding appointment as an advisor to the plaintiff company at a monthly fee of rupees 4,000. Also, there is a company has also provided company's flat for use as well as a car with telephone during the course of his employment only, limited to appointment during the course of his employment for personal, for residential use only. I'm fine.
Who has signed this document, which is dated May 24, 1984?
In right side, I have signed myself, Krishna KK Biani as a secretary. And in left side, Mr. N.S. Hun has signed as his acceptance to the terms and condition of this appointment.
Do you have the original of this document?
Sir, original has been given to Mr. N.S. Hun. We have got carbon copy.
May I tender in exhibit B, my lord? The actor question, are the contents of this document even correct?
Yes.
Exhibit B kore deben.
Yes, correct. True and correct.
Mr. Biani, kindly tell my lord, I will print the copy. Is Mr. N.S. Kindly tell my lord, is Mr. N.S. Hun a party in the suit?
Yes.
Okay, wait.
In your judge's brief of document, what the date has written in the
18.4. Lordship is in page 2.
Page 2, serial number 2, letter dated.
Oh, index has a typographical mistake. Body, it should be May 24, 1984. Index, my love, we will take steps to have this index correct. Type index, type. Index, we are very sorry, my love.
Correct it.
Yes, sir. Actually, correct. दीदी वहां से वही दिखते कि नहीं हो एक बार उनके क्वेश्चन पूरे दिन.
Yes. Defendant number 1. Full name is Nirmaljit Singh Hun. Nirmaljit Singh Hun.
Mr. Biani, kindly tell my lord, why did the plaintiff had to appoint the defendant number 1 as an advisor to the plaintiff company?
The company was pursuing for new business opportunities and new projects. Company was pursuing new business opportunities and new projects. In that connection, we have appointed Mr. N.S. Hun for new projects.
So according to you, as per the document dated May 24, 1984, which is PD2 in the judge's brief of document, the subject residential flat was to be used by the defendant number 1 only till he continues with his appointment as an advisor. Is it right?
Yes.
They already stated earlier also, during his service period.
Kindly tell my lord whether the defendant number 1 had made any payment of any sum on account of use and occupation of the flat in question at any point of time to the plaintiff company.
No. Not at all.
I'm showing you a document which is PD3 in the judge's brief of document. Kindly tell my lord, what is this document about?
This is a letter dated March 20th, 1985, written by me, addressed to Mr. N.S. Hoon, regarding termination of his services from the company. And we have asked for peaceful and vacant possession of the flat allotted to him, as well as company's car.
Who has signed this document, which you have said is dated March 20, 1985?
This is signed by me.
Are the contents of this letter dated March 20, 1985 true and correct?
Yes, correct.
May the copy be tendered to March 20. See. I'm showing you now. I'm showing you the KTD. Mr. Bayani, kindly tell my lord, how was this letter dated March 20, 1985 delivered to the defendant number 1 by the plaintiff? So,
It was sent, the letter was sent to register with post AD. Acknowledgement due.
I'm showing you the document which is marked as Exhibit PD4 in the judge's brief of document. Kindly tell my lord, what is this document? This is the, for just 1 minute, this is the copy of the envelope and the postal slip.
Yeah, this is the copy of envelope and acknowledgement, postal acknowledgement, actually, the card.
This is the envelope, comma, acknowledgement card and postal receipt.
What will these documents, which is PD4, show, according to you?
This letter was sent through registered post. Regarding termination of service.
Kindly see the second page. Kindly see the second page of PD5 and tell my lord What does this document show?
It is showing out of Calcutta, seems out of Calcutta, CAL, out of CAL, hence left.
Put a inverted comma.
There is a remark. There is a remark by the postman.
In the envelope, there is a remark of the postal authority that the addressee
out of
Calcutta, then left.
Hence
left.
Hence left. Inverted comma close.
And the remark is given on 22nd March 1985.
I'm tendering this, my lord, marked as Exhibit D.
Exhibit
D.
D collectively.
Collectively. Mr. Biani, as you have just now deposed before this court that the letter was undelivered, which was sent to Mr. N.S. Hoon, what did the plaintiff company do subsequent to this?
We have published this notice of termination. We have published notice of termination in the newspaper, in the two newspapers, one in English, one in Bengali.
Are you aware of the names of the two newspapers?
Yes, as I remember, it is Business Standard, and other name I can't remember unless I see the document.
I'm showing you the document which is marked as PD5 in the judge's brief of document. Kindly tell my lord, what is this document?
This is a notice published on 8th April 1985 in Business Standard. This notice was on behalf of STP Limited, and my name is here, KK Biani, Secretary, regarding services of Mr. Hoon as advisor has been terminated.
Maybe marked and tendered as Exhibit E.
Original है copy.
Very old, my lord.
Exhibit E.
I'm showing you a document which is marked as Exhibit, which is marked as PD6 in the judge's brief of document. Kindly tell my lord, what is this document?
This is the same notice which is in Bengali versions in Bengali newspaper.
Do you recollect the name of the newspaper?
Ajkal.
And maybe tendered and marked Exhibit PD6. Mr. Biani, can you tell my lord, when did the name of the plaintiff company change? Are you aware?
Yes, I am aware about it. It was changed in the year 1985.
I'm showing you a document which is marked as PD7 in the judge's brief of document. Kindly tell my lord, what is this document?
This is a fresh certificate of incorporation. If a fresh certificate incorporation consequent on change of name from Shalimar Tar Products 1935 Limited to STP Limited. STP Limited.
Maybe tendered and marked as exhibit.
There are two documents.
Yes.
Another document is Certificate of Incorporation in the name of Shalimar Tar Products Limited. Another document is Certificate of Incorporation in the name of Shalimar Tar Products in bracket 1935 Limited.
Both can be collectively tendered exhibit G, my lord.
Not an original.
This original. This they have taken the downloaded from the Ministry of
F.
F. There are two. G, yes. G, yes.
collectively.
Yes, G, collectively G. Mr. Bayani, how is the plaintiff company related to Turner Morrison Limited?
Plaintiff company was subsidiary of Turner Morrison Limited.
And kindly tell my lord, how is the defendant number 1 related to Hungerford Trust Limited?
Defendant number 1 alleged to claim himself as chairman of Hungerford Investment Trust.
Who is the defendant number 2, Lakshman Das Walia, in the plaint?
No, it has been amended.
In the original plaint. I'm not sure. Who is question original person? Walia.
Who was the Lakshman Das Walia?
Who was Lakshman Das Walia? The original defendant number 2.
Lakshman Das Walia was inducted by Mr. Hoon in the suit premises.
Was the plaintiff aware of this induction of Lakshman Das Walia in the suit premises?
No. When we came to know, we made an application before the Honorable Court.
So the plaintiff does not accept, according to you, the induction of Lakshman Das Walia in the suit premises?
No.
Question khatam ho jiye by the defendant number 1. Question khatam hone ke baad answer dijiye.
May I request you to repeat the question? Yeah, yes. No, we do not accept.
Okay. Who are the present defendant number 2 and 2 capital A in the plaint? Are you aware?
Two is Srimati Pritam Kaur and 2A is Srimati Saroj Mehra. Pritam Kaur is the wife of this is Lakshman Das Walia. and Srimati Saroj Mehra. She is a daughter of deceased Lakshman Das Padia.
Is Nirmaljeet Singh Hun alive? Are you aware?
No, Nirmaljeet Singh has expired a few years back. He is no more.
Few.
Few.
How the suit will continue?
My lord, that is what I was showing. If I can, there is a document which is not part of the judge's brief. If Lordship allow me, I can just.
What document?
My lord, we had Lordship order, my lord, we had published the the notice of the pendency of the suit. And this was, may I hand over the notice and the Lordship order. So the Lordship has to just now, the name of the defendant one has to be expunged, because my lord, the suit premises is in now physical possession of the court appointed special officer from last many years. Special officer. That I will show in few minutes. High Court had appointed a special officer. Actual physical possession is with the special officer. And the defendant number one is dead, so his name has to be just expunged. There is no need for anybody else to be brought on record. And this is the newspaper which we had advertised, the public notice of pendency of the suit. And when the suit was fixed, suit number is also given 1034. This was in Statesman. And there is also a Bengali, I think. Bengali name. Statesman. So the court through the special officer is in seizure of the suit property. And Lordship order we have referred is 3rd February. Because this was leave and license, because he was the employee of the company.
So nobody's in the premises?
No, it is, I will show the orders, the High Court.
No, nobody's in the premises now. This is vacant.
Yeah, vacant. Special officer is in actual physical possession.
So nobody's appearing.
That is why.
That is why the order was.
That is why, because that also then Lordship noticed that nobody is appearing. Then we said that we will go in the regular procedure. We will not try to have it to take a shortcut, and that is why we are going in the regular procedure. Mr. Bayani, I am showing you the document which is marked as PD 8 in the judge's brief of document. Kindly tell my lord, what is this document?
This is an application for permission under Section 30 of the Foreign Exchange Regulation Act 1973, seeking appointment of foreign national in the company. Mr. Hun was a British national, hence we sought permission from Reserve Bank of India in this behalf.
Where is the original of this?
The original
of this document, form EPK-1. which is PD 8 in the judge's brief of document.
Original was filed with the Reserve Bank of India.
Was this document received by the plaintiff in the usual course of business?
Yes.
The contents of the document are true and correct?
Yes.
Well, it may be tendered. It will be exhibit H. I'm showing you a document which is marked as exhibit PD 9 in the judge's brief of document. Can you tell my lord what is this document?
This is a letter dated 27th July 1984. The Reserve Bank of India granted permission regarding engagement of foreign national Mr. Nirmaljeet Singh Hoon This letter is signed by some joint controller. I can't read the signature.
And then may be tendered and marked as exhibit I.
This letter we received in usual course of business.
इसके आगे डॉक्यूमेंट है लास्ट पेज चले गए लास्ट पेज चले गए I'm showing you a document which is marked as exhibit PD 10 in the judge's brief of document. Kindly see this document and tell my lord what is this document about. PD 10 about. तो ये देखो इधर भी होता चेंज कर दो मतलब we have a or this original old type copy made means the type copy of the RBI document. It
चेंज कर दो एग्जिबिट एच को चेंज कर दो
H and I exhibit.
Keep along with it.
X on the though this lordship no these were the second old papers this normally the second copy thought at that point of time. Become a PD no ये तो पढ़ा ही नहीं पाया था वो मैं दोनों भी Why are you giving illegible paper? जो दिखाओ एक बार क्वेश्चन है
Not mark appearing. Okay. Appearing at.
This is a letter dated May 22nd, 1985, which was sent registered with AD, written by myself to Mr. N.S. Hoon regarding reminder for handover of peaceful possession of suit premises as well as company's car, which was allotted to him during the course of his employment with the company. And
who has signed this letter?
Myself.
Are the contents of the letter true and correct?
Yes.
Kindly tell my lord, how was this document served upon Mr. N.S. Hoon, the defendant number 1?
This letter was sent under registered ready post and which was received by one Mr. G.D. Ray on behalf of Mr. N.S. Hoon.
Received or refused?
Received.
May both these there are 2 pages. मेरे में 2 है. Both this bunch be marked as Exhibit J collectively. They are very old postal slip and AD cards. I don't know how they have kept it. Those time the emails were not there.
Collectively, huh? Yes, next.
I'm showing you a document which is appearing as PD 11 in the judge's brief of document. Kindly tell my lord, what is this document?
This is another letter written by myself addressed to Mr. N.S. Hoon on August 28, 1985. Again asking for peaceful and vacant possession of company's flat This letter was sent by registered with AD.
Who has signed this letter?
Myself.
Are the contents of this letter true and correct?
Yes.
Kindly tell my lord whether this letter was served upon the defendant number 1, Mr. N.S. Hoon. This bunch, the letter and the acknowledgement, these are all together. When it goes, it will go as corrected.
Give the paper to the witness.
Paper don't अपने आप देखिए.
The letter which was addressed at 16 Park Mansion, addressed to Mr. Hoon. Returned undelivered with the remark out of Calcutta, hence left. Remark out of Calcutta, hence left. There was another address at which notice was sent, that is N.S. Hoon, A-1/63, Azad Apartment, Sri Aurobindo Marg, New Delhi, 11,16,000. It was received by some S. Hoon on 31st August 1985.
Who has signed this letter of August 28, 1985?
Myself.
Are the contents of the letter true and correct?
Yes.
The letter may be exhibited as K and the acknowledgement card says L. Both the acknowledgement card may be collectively L coded. Our letters are K. K.
Yes, next.
Mr. Biani, kindly tell my lord who is presently in occupation of the subject flat.
The subject flat is under the possession of court-appointed receiver.
Since when is the receiver in possession of the flat?
From 1987 onward. Sorry, I'm correcting myself, sir. I can't remember the exact date. Maybe 92 or earlier it was taken on symbolical position. Then maybe 92 onward.
Aste.
And thereafter, as I remember, from 92 onward, it was in physical position.
Earlier,
initially it was in the symbolic position of the receiver, and subsequently, probably from 1992, it was with the receiver. The physical position is with the receiver.
I'm showing you the document which is appearing at PD 13 in the judge's brief of document. Kindly tell my lord what is this document?
This is the report of receiver. Who visited the flat, suit premises, who visited the suit premises on 31st October 1987. There is also minutes of the proceedings held by the receiver
Receiver report है उसमें.
on 31st October.
What is the date of the receiver's report?
November 1987.
And may the report and the minutes be together.
The original. Where is the report?
Original report is not there. We have the photocopy, but it is. We were given the copies. Report and the minutes is part of the report.
Dated?
What is the date code? I think he said
November 1987.
very old. Both the report, I think, then the minutes must be together. Minutes साचे होंगे तो.
No, that is second one. What's the first? अलग होगा.
हाँ, Exhibit M. X होंगे present collectively.
Original kept in the report that will take. How it will go? Original kept in the report. The Xerox will be exhibited. Because it is the court record. That will be exhibited.
I'm showing you. Sorry. This is the last one. I'm showing you this document which is appearing as PD 14 in the judge's brief of document. Kindly tell my lord, what is this document about?
This is a judgment passed in the year 2002 and reported in, sorry, it is reported in 2002-1. No, it is reported in 2000.
What is the document?
This is the judgment passed by this court.
Why in which case? This case?
This case.
So why it is exhibited?
To bring it on record, the physical possession is with the
So it
special,
might be
because
so.
that from that it will not appear.
Now, how it can be exhibited of the same court order?
And maybe
You produce at that-
on record. We have the copy, my lord.
No, you produce at that time argument.
Not-
There's no necessity of exhibiting because the order passed by this court in the same proceeding. So
Mr. Biani, kindly tell my lord, who is presently in possession of this subject flat?
I have already answered. This flat is presently in possession of receiver appointed by honorable court, this court.
Mr. Biani, what is the relief you are seeking in the plaint filed in the suit?
We are seeking relief, peaceful and vacant possession of the suit premises, as well as master profit.
as well as
Master profit.
men's
Mean
profit.
Huh? 5 lakhs. 5 lakh.
That's all.
That's all, man.
Anything?
I'm led by Mr. Bose. Today he was stuck in another court, so he has just asked for you kindly give him 5 minutes on the next day. Kindly do not
Through
formally
court, through
close it
court,
today.
through court. So none of the defendant are in occupation of the premises as of now?
No, sir. My lord, no, my lord.
I'm told that this is again appearing tomorrow as 2 p.m. Lordship given us 2 days. So Mr.
tomorrow?
Yes, that is what I'm told. So Lordship may
No, but that's why you inform Mr. Bose.
Yeah, I will inform.
Because the defendant number 1, though you have published a notice and you expired, it is on record. You have to take steps.
That we will apply the Lordship tomorrow.
Okay, please get. So appearing for the plaintiff.
The next matter is also maybe tagged tomorrow. Both are kept tomorrow.
That's why tomorrow.
If after one is over, we'll go to the second one.
Come tomorrow in that second question.
No, this one we will take 5 minutes
Okay.
and then go to the second.
Plaintiff witness is present. Plaintiff witness is present. And his examination in chief is concluded. Chief is concluded. Examination in chief is recorded.
Just give 5 minutes tomorrow.
And during his examination in chief, Exhibit A2, Exhibit A2, Exhibit M were marked. Counsel for the plaintiff prays for time. Accordingly, chief is deferred. Let the matter appear on 12th December 2023 at 2 p.m.
My love, the
2 p.m.
second matter, probably the papers are not ready. So we will only pray a lordship for the first item. Second matter, for the time being, my love, I'm told that the records are very old. We could not collate.
Complete because the old matter.
Yes,
so
sir,
we will dispose of the
in
matter.
case my love, probably second matter will not be taken up tomorrow.
41. With regard to the 42, not 41. With regard to 41, let the matter appear tomorrow too.
Grateful.
Not today. Yes. Yes, Mr. Junjanwala. Board resolution is there.
My lord, yes, papers have come, my lord. My lordship. The
Which
original
was the other
power of
side?
attorney, my lord. They had raised the objection.
That's why the power of attorney is shown on the last occasion.
My lord, they had said that there is no common seal. If your lordship kindly see on the right side at the bottom of the last page, the red common seal, my lord. And on the left side, if your lordship see, there is a watermark common seal of the notary. And on the reverse, if your lordship kindly see, there is a High Court of Hong Kong. Those seals are there, my
Who is
lord.
the other side?
They were supposed to be here, my lord. Let me show to your lordship at least the document. I will supply to them.
Let they inspect the document.
The lordship will kindly see about the resolution. The point which they had raised, my lord. There is a common seal and it said authenticity of the resolution is covered by this document.
Yes.
So what I was submitting, my lord, I will supply to them these copies and send the original for their inspection. Your lordship will kindly see. Your lordship will kindly see the original power of attorney on the reverse. They have inspected. Similarly, I will send this also. They will inspect it. I'll give a copy to them. And then on next date, I'll file it before your lordship. Then your lordship can pass the order. And I will inform them of this.
Mr. R.N. Junjunwala, learned advocate appearing for the defendant number 3 is present and appears on behalf of the plaintiff. Mr. Junjunwala has handed over the original copy of the resolution of Hong Kong Hui Hong Industrial Company Limited, wherein the board of directors of the company have authorized Mr. Shankar Day to represent in the said case to the defendants. Mr. Junjunwala is requested to communicate this resolution to the learned counsel for the plaintiff. And the plaintiff has the liberty to inspect the original. Let the matter appear on 4th January 2020.
Your lordship will make it 5th January, 4th January, I have cases.
5th January 2020.
My lord, I must place on record my appreciation the way your lordship directed, and we learned something how to be perfect.
I am learning from all of you.
I'm speechless, my lord. I can't say anything.
I appear for the defendant in item number 44 and the plaintiff in 45.
Yes.
My lord, the plaintiff's witness was in the box.
Yes,
My lord,
my lord.
40.
I am for the plaintiff in the, my lord, item number 44. My lord, my witness is here, my lord.
Let me. I won't take too much time. I have just about 8 to 10 questions. My lord.
English Hindi just. No, no. Deepak Agarwal. DEE.
Mr. Agarwal, I'm showing you a document which is DD3, appearing at pages 13 to 15 of the defendant's judge's brief of documents. Please have a look at this document and tell my lord if you recognize this document.
I have already answered this that I don't recognize this.
I already answered that I cannot recognize this document.
It is therefore your evidence that the signatures appearing on this document are cannot be identified by you.
I've already answered these questions you have asked me earlier. I don't recognize this document.
Judges brief a paper copy. Please come to page 3 of this document. You have said on an earlier occasion that the signatures of Mr. Basudev Agarwal appearing on this document do not belong to Mr. Basudev Agarwal and that they are evidently different. Can you identify how this signature differs from his original signature as you claim?
Some of the words are different. I told you, you asked me specifically many times. I can't specify as I am not that much expert, but
I have already stated on the earlier occasion that some of the words are not with the signature of so and so, and I already but I cannot specify totally because I am not the expert.
Would you agree that the agreement between the parties originally contemplated 51% shares to be made over to the defendant group by the plaintiff group in the company Bhumi Minerals?
yes, I think so. It is that way. That way.
I put it to you that after this agreement or MOU was executed between the parties on September 20, 2010, the very next day, the plaintiffs, namely Basudev Agarwal and Suresh Agarwal, had made over an amended MOU, thereby changing the essential terms of the contract between the parties.
I disagree.
I further put it to you that the reason for the defendants to cancel the agreement was because the shareholding to be transferred was sought to be reduced from 51% to 49%.
I don't agree.
This document that I have shown you being DD3, when was the first time you saw this document?
This document we saw first time when we were served a copy of the plaint in case 264.
Would you agree that this was sometime in or about the year 2012?
Yes.
Have the plaintiffs or you taken any steps to challenge this document by filing any proceeding?
We have filed our written statement in this case, and the case is pending here before the Honorable Court. So we have, that is the step we have taken. Sorry.
That is the steps we have taken. So I take it that you have not sought any declaration or cancellation of this document which you and the plaintiffs claim to be not a genuine document. Am I correct?
We are not acknowledging this document. We don't recognize it. We are not acknowledging this. We don't recognize it.
May I tender this document for it to be marked for identification because it has not been proved. These are all.
Thanks for identification.
One other thing, I don't know if the plaintiff has any other witnesses, but if
We don't have any other witnesses.
this is the only witness, we have one witness, I have taken out a formal application, which is IAGA number 3,
That is
also appearing in
their
elections.
suit, my lord, in item number 40.
Both the suits are being heard analogously. Subject matter is one and the same. I am asking for recovery and refund of this 1 crore that I have paid. They are asking for a declaration that this 1 crore has been forfeited. There is an earlier order, 2017, that they should be heard and tried analogously. And my application is for appointment of a commissioner to take down the evidence of the defendant's witness.
Witness on a commission.
Yes, on commission. Due to his old age, and I've also annexed a medical certificate, he's 70 something. That is
Yes,
the only.
please step.
My lord, I am opposing the application for commission because if my lord kindly takes that application once, my lord.
What is the GA?
GH3.
My lord, page 6, my lord, paragraph 4. My lord, my lord, if I may place, having regard to his advanced age and age-related ailments, it would become extremely burdensome for the witness to be asked to be physically attend court for the purpose of giving evidence on behalf of the plaintiffs. In such view of the matter, it is necessary for appropriate orders to be passed for the purpose of appointment of commissioner. My lord, now my lord kindly sees the last 4 lines of that paragraph. A certificate issued by the medical practitioner under whose care and supervision the plaintiff's witness is presently under medical treatment is annexed. Now, my lord, the annexure is at page 12. If my lord kindly takes. My lord, first of all, my lord, this is, my lord, an OPD prescription issued by Shibrampur Bhushan Chandra Haldar Memorial Sheba Sadhan. My lord, which is, my lord, a unit of Social Welfare Association and Research Center. My lord, the doctor's name, my lord, is given R. Mondal. There is no, my lord, doctor's credentials given, nothing. And my lord, bottom left, my lord, it is indicated that the witness is advised rest for 2 months. Now, my lord, this application was affirmed on, my lord, 14th September 2023. The 2 months period has expired, my lord, on November, my lord, 14, 2023. My lord, today, my lord, we are in December, my lord, he can come and depose before my lord, my lord. And my lord has been very accommodating throughout, my lord. My witness also is coming from, my lord, other state. My lord has given, my lord, time, my lord, for him, my lord, to come and depose.
No, that is correct. But
yes, my lord.
this
This won't be a difficulty, my lord.
court is giving time, and as per the choice
Absolutely,
of the advocate, there is no. But if the witness, what purpose should be served if it is rejected? Go and commission. You will get the opportunity to cross-examine.
My lord, we want to cross-examine before, my lord.
He will bear the cost of the commission.
Understood, my learned friend's objection is the date. 2 months, and she is right.
Not only that, my lord,
Allow me, please, I did not interrupt you. 23rd August, this application was affirmed. If my learned friend wants, I will file a supplementary. It will only protract matters.
My lord,
I don't see the point. And
See,
just because
I was also the practitioner of that side. I am not willing upon the documents of the doctors and all these things,
my lord.
other commission. But if the person, if commission, if you are facing any problem in the commission, then that is a different thing.
My lord, I bow down to that. But my lord, only one thing, my lord. I don't know why, my lord, the witness is shying away. My witness
is he
has
shying
come.
away?
My lord, this is my lord.
My learned friend has
My
no
lord, the
confidence in a
prescription.
commissioner appointed by court.
Prescription, my lord, kindly
I will
see.
bring up
It's
fresh
not a credible
prescription.
document.
If you want, I will appoint some senior
Yes,
person so that in his presence this can be given, not
the question of
for junior. It can be done, or where he will appear.
residence.
Where is
Near Science City. Lordship appoint someone
he's
from
a
the
resident
north.
of Science City.
He's a resident of Science City.
In his house, he want to examine.
It will be best, my lord. Or somewhere nearby in the vicinity. Someone from
At the cost and
they will.
yes, of
they
course,
will-
naturally, naturally.
Because their application.
A mid-level, someone your lordship may appoint.
Sons appearing for the plaintiff, sons appearing for the defendant. It was your witness, plaintiff. Your
my lord, my witness.
plaintiff witness is present and its cross-examination resumed and concluded. Counsel for the plaintiff submitted. She will not adduce any further evidence. Accordingly, evidence on the side of the plaintiff is closed. Full stop. The defendant has filed an application being GA3 of 2023, praying for examination of his witness, namely
Namki?
What is the
Mr.
name of
Nirmal
your
Kanodia. Who is
Nirmal Kanodia.
Nirmal Kanodia.
My lord, he is the plaintiff number one
in my
the
suit
second suit.
and in my learned
He is the
friend's
defendant.
My lord.
So evidence of both the one is
He is
That is
defendant
serve
number
the purpose in both the cases.
yes. He is defendant number 1 in item number 44.
The defendant number 1 in CS number
124.
264.
No, my lord, 124.
120.
124 of 2011.
124 of 2011 and
Plaintiff number 1
number 1
in 264.
CS number 264 of 2012.
Yes.
Praying for his examination at his house on commission. Counsel for the plaintiff submit that the witness Nirmal Kanodia is aged about 71 years and is also suffering from various ailments, and it's not possible for him to appear before this court in person to add his evidence and prayed for appointment of commissioner. Learned counsel for the plaintiff raised objection and submitted the medical document submitted by the witness dated 9th August 2023 reveals that the doctor had advised for arrest only for 2 months and 2 months has been completed, and as such the witness can very well appear before this court for his examination. We'll consider the submission made by the counsel for the respective parties, peruse the application and the document submitted and the medical document submitted by the witness. This court find that it is proper, and this court find that the witness is 71 years old and also suffering from various ailments, and as such it is appropriate to appoint one commissioner to examine the said witness on commission at his home. Accordingly, any choice name, both if the common name you both give, then I will appoint.
The senior hall. And learned friend says Mr. Nilmallo Dasgupta, I don't have any objection.
So and so having give the number.
Yes.
Is appointed as commissioner for examination of the defendant witness Mr. Nirmal Kanodia at his residence 2/7, Sarad Bose Road, Vasundhara Building, room Roman 5, number 3, Kolkata. This, but permanently resident at what is the number?
Address to follow.
Resident of 1001A Eastern Metropolitan Bypass, Kolkata. This is the address.
This is the one. No.
Or
No,
Sarat
it-
Chand Bose Vasundhara Building.
My lord, this, yes, your lordship is right. 101-1001A Eastern Metropolitan.
Address resident 1001 capital A Eastern Metropolitan Bypass, Kolkata. Kolkata. The remuneration of the commissioner is fixed at rupees 20,000 per day per sitting, and the remuneration shall be paid. Remuneration of the commissioner shall be paid by the defendant. Full stop. The commissioner shall inform the date of examination of the witness on commission to the assistant registrar of this court, so as to enable the officer of this court to produce the document before the commission at the time of examination of the witness on commission. Full stop. The commissioner is directed to complete the examination of the witness on commission within 4 weeks. It will be over.
4 weeks. But 6 weeks, your lordship makes.
Within 6 weeks from the date of receipt of the order. The commission is directed to submit the report. Today we are on 11. On 31st of January 2024.
Extremely grateful.
GA number 3 of 2023 is disposed.
My lord, I appear on behalf of the defendant number 14, my lord.
Item number?
Defendant number 14.
I am for the receiver advocate, my lord.
Yes.
My lord, the receiver has filed accounts and we need some time, my lord.
What?
We need some time to take out an exception, my lord. There are around 10 lakhs of gross negligence. We need to find out. The client is willing to give us time. We need a little bit more time, my lord. 7 years of accounts, my lord, we need to go through.
Have you received the copy of the report?
Yes,
My lord,
yes,
on the
yes.
court, we have.
Yes, my lord.
You are for the plaintiff.
No, my lord. I'm for the defendant number
Who is for
14,
the
my lord.
plaintiff? Mr. Paul? Yeah.
No. Yeah, I'm
You are for the defendant number
14, my lord.
Huh?
14.
14. What about the other?
Haven't come.
They're supposed
My
to
lord,
file the exception.
it's my lord plaintiff and defendant number 14 have defendant number 8 have instructed me the same thing, that we need little bit of time.
Nobody's here.
We need little bit of time for the exception to take.
Counsel for the receiver is present. Learned counsel for the defendant number 14
Yes, my lord.
is also present. None appears on behalf of the plaintiff and the other defendant. The auditor has submitted the report after serving the copy to the who has submitted this report? Receiver?
Receiver's report, yes, my lord.
No, this audit report?
Audit report filed by receiver.
My lord,
Receiver.
7 years of accounts in a single page.
Receiver has submitted the report, audit report, after serving the copy to the learned advocate for the respective parties. Let the report be kept in the report. The counsel for the defendant number 14 prays for time to take exception to the audit report submitted by the receiver. Let exception be filed by the parties within 2 weeks from date.
My lord, 2 weeks after the vacation, my lord, please.
No vacation.
Kind
Then
lord,
we are on
kindly,
11.
my lord. My lord, we need to get
Within
in
3
touch
weeks,
with the accountant.
Within 3 weeks, let the matter appear on 9th of January 2020.
Grateful, my lord.
Great. My lord, item number 25, same, my lord.
Same.
Same.
Report also there.
Report filed.
My lord, it's the same matter. It's a separate GA, my lord, for the for injunction the plaintiff have filed.
Item number 25.
5.
Okay, now look. Combined query.
My lord, I am appearing on behalf of the plaintiff petitioner, my lord. My lord, may I be permitted to file my affidavit in reply to the opposition filed by defendant number 8, respondent number 8.
I appear for. Have you saw the copy?
My lord, I am serving the copy.
Saw the copy.
My lord.
Yes.
My lord, defendant number 8 is not appearing right now.
My lord, I am appearing for defendant number 8.
My lord's last order.
You are appearing for whom?
Plaintiff petitioner, my lord.
You are for the plaintiff petitioner. Yes, you are appearing for defendant number 8. Defendant number 8.
Gajanan. I'm appearing for defendant number 7. My lord, defendant number 8.
Actually, there is dual representation on defendant number 8. My lordship has asked us who will represent. My lord, myself, Mr. Auritra Basu appears for defendant number 8, and also Mr. Shankarsan Sarkaran.
So now the matter is settled between you. No, it's still
my
going
lord.
on.
It's still going on.
My lord, in the
My lord,
department, Mr.
my lord,
Aditya
last
Kanodia has
petition-
filed his wakalatnama.
Huh?
For defendant number 8, Mr. Aditya Kanodia has filed his wakalatnama. I'll be serving a copy on Mr. Kanodia, my lord.
So,
May I be permitted to file my
file it.
grateful, my lord.
What about the plaintiff?
My lord, we have my lord, affidavits are completed, my lord. My lord, may be pleased to fix this matter as per my lord's convenience.
What is your objection? Yes, Basu is appearing for the defendant number 8.
Yes,
There
one
is
of that.
dual representation for
Whether
defendant number 8.
Sarkar
my
or
lord.
whether Basu.
Well, the issue is unresolved. Well, the reason I tell your lordship is, well, it's my contention that I am in control of the board of the defendant number 8. Now, my lord, in a action under section 397, 398, an application has been filed by the other group saying that the Vakalatnama which has been filed on behalf of Mr. Noshkar should be cancelled because the board did not authorize him to act on behalf of the company. And I'm those I have filed the reply affidavit, it's pending adjudication, and my counter application is also filed for dismissal of their application. Now the issue is sub judice. Now, till the time the final outcome is received or the final decision comes from the NCLT, lordship would kindly allow dual representation for the time being.
My lord, I've been serving copies to both of them.
Whom he will serve the copy?
My lord, in the last occasion, my lord will
Reply. Whom he will serve the copy? Either you or not.
Well, what we can do is that I'll not trouble my learned friend to serve copies. Malad, what I can do is that I'll tell Mr. Noshkor to get a copy of the application from Mr. Ray. We'll get it photocopied at our own cost, and Malad, we'll do the needful. Because I do understand it is not possible for him to serve copies to different persons who are representing one entity. But we'll do that on our own way.
My lord, on the last occasion, had directed us to serve copies in the company itself, defendant number 8, at the registered office. We have done that also, my lord. And filed our affidavit.
The reason, Malad, why I am not getting the copy is, Malad, because now the registered office has been taken complete control by the other side. Now, Malad, that is the main objection, because Malad, a board meeting was convened illegally. Now, Malad, they took control of the board. Malad, my nominees or my representatives who were there on the board, they were illegally removed. And Malad, now, Malad, they have taken complete control over the registered office of the company. Malad, this is the issue. That is the reason why if my Mr. Ray serves a copy of the application at the registered office of the company also, Malad, I will not be able to take a copy of that application.
How much time it will take before the NCLT?
Well, it's going on, Malad. And Malad, hearing matters, it takes time, Malad.
My lord, if I may submit,
what is the
Mr.
application you have filed? What's your
My lord, receiver to take physical possession, my lord.
physical person
of the property, suit property, Mangala Hut, market, my lord.
Acha, that.
Yes. GA10 and my lord, GA4 is also a receiver application which is pending, my lord.
Now, who is in possession of the property?
The third person are in possession of the property, my lord.
The only thing, Malad, if I get a copy of the application, I can indicate my objection because, Malad, what will happen if I do not object to the prayers which are detriment to the company, Malad, they will use this proceedings order and they will go and show the NCLT that, Malad, I have not been taking steps to represent my company or I have not been taking steps to enforce my right. They will show that I have relinquished my right to represent the company. Malad, that will be prejudicial to me.
At present, whose wakalatnama is there?
Mr. Kanodia's wakalatnama is
Mr. Adit.
My lord, Mr. Kanodia is.
Yes.
I have filed an affidavit, my lord.
I filed my reply. I am serving you.
You have received.
No, my lord, we have not received.
Reply file.
Reply file.
I don't have.
I have just filed my reply. I'm giving you, handing over
No,
the copy. My
The
lord, I shall
plaintiff
hand
has
over
filed
my
a
copy
reply,
right
not
to
to
you.
my opposition.
Okay. So when can be fixed?
On any day, but one only thing, my lord, if my Mr. Noshkur is given copies, my lord, he'll get it photocopied at his own cost, and we'll do the needful. We'll not trouble Mr. Ray's
No,
client.
officially, my lord, I will be objecting to this. Because I don't recognize that the board under whose instruction Mr. Naskar is appearing. Learned friend wants, my lord,
You gave it.
yes, my lord.
My lord, on the last occasion, Mr. Shohitnath Mitra leading Mr. Kanodia had told that we will.
Thereafter, my lord, nobody asks for it.
Okay, you give it.
I'm serving a copy, my lord. I'm handing over a copy, my lord.
There was a
Sense appearing for the
assurance
plaintiff.
by Mr. Kanodia, he will give it to me.
Who is for the defendant number 7? Sense appearing for the defendant number 7.
Define number 7.
7. 7. And so appearing for the but for the defendant number 8, two groups of the advocates are appearing. Full stop. Counsel for the plaintiff has filed affidavit in reply in connection with GA10.
GA10, my lord.
GA10. After serving of the copy to the learned counsel for the appearing parties, let the same be kept in the record. It is submitted that pleadings have been completed.
Pleadings have been completed.
You are not filed.
Yes. It is. I am being led by Mr. Mitra.
Let the matter appear on
Reply to
10th January.
10 Jan.
Mr. Mitra is appearing for?
He is leading me, my lord. Defendant number 8.
Okay. Sir, I recorded that. Settle it. Who will appear for the 8th? There are two
So far as this application is concerned, my lord, I don't think that there is any dispute between us.
But both are appearing.
Maybe. For benefit of the profession.
That's why I recorded for two sets of the advocates. 10th of January. Come ready on GA10 can be taken up for here.
GA10,
I am not fixing, then it will go. Huh?
Gives us a slot, then
It will appear in the list.
Then it will go again. And after 2. At 2, 3. Then it will go to February.
My lord.
Achha, it is under order for orders. It will come
For orders.
the head for orders.
10th of January.
In January.
Because I am keeping the slot of 4 orders. If hearing matter is not taken, then orders matter can come.
Play file. Record it.
Hello, I am appearing for the respondent, my lord.
My lord, I appear on behalf of the petitioner.
GA number 6, GA number 5, my lord. I need to file my reply, my lord. Affidavit, I pray.
You are appearing for?
I am appearing for the respondent, my lord. The widow, my lord.
My lord, in
I
GA,
filed my opposition to GA number 6, my lord.
my lord, in GA5, we have already served a copy of the affidavit in
was
opposition.
served,
May I
my-
file it in court, my lord?
Who has filed the GA5? You.
GA5 is my.
So you want to file reply?
I want to time to file because the opposition was served.
What is the GA5 for? Extension of time to file affidavit.
Yes, my lord. Extension of time to file affidavit in support of KV.
And what about the 6?
It
Discharge
is
of
an
KV.
application for
My lord,
dismissal of the
GA6 is my application.
Discharge.
for discharge.
Yes, my lord.
So both counter. So you filed on GA6 you have filed your reply.
My lord, in GA5, we have served a copy of the opposition. May I file it in court, my lord?
My lord, I have also filed my opposition to
And
GA.
what about the GA6?
My lord, GA6, we are seeking for some further time to file the reply, my lord.
Reply.
Yes, my
Both the
lord.
party want to file reply.
Yes.
So and so appearing for the petitioner, so and so appearing for the respondent. Petitioner GA5. No. Respondent in GA5 has filed affidavit in opposition, and counsel for the petitioner in GA5 prays for time to file affidavit in reply. Counsel for the petitioner in GA6 of 2023, respondent in GA6 of 2023 has filed reply opposition, and the counsel for the petitioner prays for file reply, time to file reply. Let affidavit in reply in both the cases be filed by the respective parties within a period of 2 weeks.
Yes, my lord.
2 weeks. List the matter on 9th of January 2024.
Can you kindly record that, my lord? I had filed my opposition to GA5.
I recorded
Grateful, my lord.
for hearing of GA5 and GA6.
Grateful, my lord. My lord, item number 28, I appear for the petitioner. This is my probate application, your lordship. I have also taken out an amendment application. Now, the facts in brief, your lordship, by an order dated 21st of June, your lordship was pleased to direct the department to issue general citation, special citation, and paper publication is also complete. However, in the meanwhile, lordship, the special citation has been returned with the endorsement. Address is insufficient. So, lordship, the petitioner is the stepdaughter of the legal heir of the deceased testator. She's not been in contact with her since her birth. She's caused extensive search of the actual address, and we found the remaining address, your lordship. I am only praying that the amendment may be allowed so that the address can be amended and a special citation then subsequently be again issued.
What is the amendment you have paid
Lordship
for?
kindly comes to page 18.
18.
1-8.
Hmm.
It has been underlined, your lordship. Flat number 65, ground floor, block number 12. Only this portion has to be included, your lordship. That is all.
So and so appearing for the petitioner. Whereas the petitioner has filed an application for amendment of the address of the one of the legal heir, namely Meeta Chaudhary, as appearing in the proposed amendment annexed with this instant application. Consider the submission made by the counsel for the petitioner, peruse the record. There A to D of the master summon is allowed. GA3 of 2023 is displayed.
I'm deeply obliged, my lord.
My lord, I appear for the plaintiffs in this matter. Today, my lord, general application number 6 is coming up, my lord, which
What
is an
is-
application under section 15 of the Commercial Codes Act, my lord.
Who has filed?
It is at my instance, my lord.
Why?
My lord, this matter is commercial in nature, and my lord, this would be evident at page 25 of my application, my lord. The nature of the contract is for construction of a building, my lord. This, my lord,
At construction.
construction, my lord. This, my lord, is clearly falling under provisions of section 2, subsection 1, 6, my lord, of the Commercial Codes Act.
Yes, madam. Who is appearing? You.
I'm appearing for the defendant.
What is-
My lord, I do not have any objection to the
No
application.
objection.
No objection, my lord.
What is a prayer? Suit. Decree.
Yes, my lord. Pardon me, my lord.
In the suit, what is a prayer? He
My
has
lord.
not completed the contract.
No, my lord. We're praying for damages, my lord.
He has not.
Yes, my lord.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full list of plaintiff has filed an application being GA6 of 2023, CS number 226 of 2018. Praying for transfer of CS number 226 of 2018 from this court to the commercial division. Counsel for the plaintiff submit that the contract between the plaintiff and the defendant is with regard to project for construction of the first steel building in Kolkata, and as such the nature of the suit filed by the plaintiff is commercial in nature and is covered under section 2 within bracket C within bracket 1 of IIX. Which one? Which?
21C 6, my lord.
6 within bracket Roman small 6. 1 6 1. No, not Roman. Numerical 1. 6. Construction infrastructure. 2C numerical 1 within bracket 6 of the Commercial Court Act. Consider this counsel for the defendant raised no objection and submit that the contact between the plaintiff and the defendant was commercial in nature and the suit filed by the plaintiff is of commercial in nature. Consider the submission made by the counsel for the respective parties. Peruse the documents. This court find that the suit filed by the plaintiff is commercial in nature and required to be transferred from this court to commercial division. Accordingly, prayer A, B, C, of the master summon is allowed. The parties are directed to comply with the provisions of the Commercial Court Act within a period of 2 weeks. Let the matter appear. Full stop. GA number 6 of 2023 is disposed of. Let CS number 226 of 2018 along with the connected application be listed before the commercial division on 10th of January 2020.
Good for your lordship.
My lord, I am for the plaintiff in the partition suit, my lord. Had directed us on the last occasion to exchange the suggested issues and kept the matter for framing of
Yes,
issues, my lord.
discovery session completed.
My lord, on the last occasion we had submitted, my lord,
No
that
other
we are
document.
relying on the documents
Yes.
mentioned in the plea.
You are for the plaintiff.
Yes, my lord.
Yes, madam. Where is your suggested issue?
Well, I am for the plaintiff, my
My
lord.
lord,
Who is for the defendant?
None.
Rashi Datta. Mr. Datta is not here.
my lord, he was here on the last occasion, my lord.
But a suit for partition.
Yes, my lord.
What is the defense they have taken in the written statement?
My lord,
Will.
my lord, yes, my lord. They are relying on a will, my lord, but my lord, those are separate proceedings, my lord. There are judgments to that effect that the partition suit cannot be stayed because the testamentary proceedings are
Now, whether the
pending.
testamentary proceeding going on?
No, my lord. And on that apart, my lord, we have taken a point in our plane that the testamentary proceedings are defective, my lord.
No, whether they have taken out any PLA has filed.
My lord, they
The
had,
application was filed for grant of probate.
yes, my lord, they had
It is
filed an
pending.
application for grant of probate.
What is the stage of the PLA?
My lord, Miss Sinha is appearing online, my lord. She would know about the status of the PLA, my lord.
My lord, am I audible?
Yes.
My lord, I apologize for appearing online. I am in some personal difficulty. My lord, the PLA was filed initially marked as defective. Recently, my lord, it has come to be numbered, and the plaintiff has filed a caveat and an affidavit in support of caveat also. But the PLA has never appeared before any court.
What is the year of PLA?
Lordship, it is 2023, 136 of 2023.
Yes, they are filed.
Yes, Lordship, it was filed way back, but since it was lying defective in the department, it was not numbered in the year in which it was filed.
So nobody is there. What can be done? I am fixing after a week. If they will come, otherwise I will frame the issue.
Grateful.
Constituents appearing for the plaintiff. And Ms. Sinha is appearing through virtual mode on behalf of the plaintiff. None appears on behalf of the defendant. Plaintiff has filed the suggested issues in terms of the order dated 13th May 2022. Let the same be cut with the record. As none appears on behalf of the defendant and no suggested issues have been filed. For the interest of justice, the case is adjourned for a week. Let the matter appear on 20th December 2023 for framing of issues. It is made clear that on the date fixed, if the defendant will not appear, issue will be framed.
I'm grateful, my lord.
Deeply obliged, Lordship.
I'm appearing for the plaintiff's minute.
Yes.
When an application has been taken out,
31 one of them is appearing, that is GA26, GA25 as well as GA27. So if it could be taken together, in not this is supposed to be taken all together.
yes, 26 is an application which has been taken out by the added respondent numbers 2 and 4 and 27 is due to appear on the 19th, I believe. I hope my learned friends agree with me on that.
It's 19. We have used an affidavit application.
So, may I also use an affidavit in this application and let all be taken up together?
Who has filed the GA26?
This is my application. Our application, your lordship will recall, regarding one of the parties died in Belgium. We are unable to get the death certificate. That is the issue which is here. And the other, your lordship probably has already granted by constituting the interim board.
That's why they have filed an application.
They have filed an application for recalling, but your lordship, pendency of their recalling, your lordship also devised a procedure on October 18th by which the company will be run for the time being under this constituted board. So for the time being, there is only one prayer which is remaining in GA number 26. That
And I would like to file an affidavit to that.
And the death
29 by 29 you can file the affidavit.
29th,
19th, sorry.
Yes, 9, that's what I thought, Yes, I think we should file by 19th. Shouldn't be a problem.
She kindly considers my prayer, page 23. Kindly see
What is the scope of an interim prayer?
Where B and C are more or less granted. Because
that is, whether Mr. Sen is pressing for that or not, that is first. If he's pressing for it, I want to file an affidavit. If he doesn't want,
no, Mr. Ray, the prayer B is connected with the prayer which you have made in your application.
That is why I said, these should be heard together.
Okay, I am fixing on 19th.
Yes. Death certificate, there can be no opposition to this.
No, may I give give an affidavit, and I want to take the point of maintainability of also of this application.
He wants to
I
produce.
want to take the point of maintainability of this application, my lord.
Without an affidavit, he can give the document. He has the
So,
privilege.
It is
Here,
important.
who is
because
appearing?
it's a
Mr. You are Mr. Sen is appearing for
My lord, the applicant in GA number 26.
applicant. Mr. Sen.
My lord will kindly, my lord, keep the point of maintainability open, my lord.
About
Saket Sen, learned advocate appearing for the applicant in GA 26 of 2023. Mr. Anirban Ray, learned advocate appearing for. You are appearing for Mr. Ray?
The plaintiff, my lord, plaintiff.
For the plaintiff, submit that. The connected application being. What is your GA number?
27.
GA number 27 of 2023 is listed on 19th of November 2023. And trace for fixing GA number 26 of 2023 along with GA number 27 of 2023.
Very grateful, your lordship.
Submission made by the counsel for the respective parties. Let GA number 26 of 2023 be placed along with GA number 27 of 2023.
My lord, GA 25 is also appearing on that.
2023 along with GA 25 2023 on 11th of
on the same
19th of November 2020.
Obliged.
Please.
All 20s appearing together, my lord. Very grateful.
That come all should be decided at one stretch.
Well, he has the privilege.
Decide.
If you want to decide to separate that, then
Pass an order, one, Mr. Rai will have to appear here on
Personally.
Mr. Rai, all the advocates are
Yes, I will. I submit.
Otherwise, I will also.
My lord, I have appeared before your lordship in the morning, my lord. I had a very important.
Otherwise,
But I was suddenly called by one of the courts here. So I rushed back. But by the time I couldn't rush back to your lordship's court.
We are missing his appearance actually.
Obliged.
It's a pleasure.
My lord, subject to lordship. Subject to lordship permission. At number 33 and 34 is short matter, and only delay is gone down, my lord, or nothing more. Very short
let
matter.
me see how far this court will go. If it time permit, I will take.
We had concluded, my lord, it was my application on Order 7 Rule 11, plaintiff first.
Well, would it be my lord, pleasure, my lord, to keep my lord's board, my lord?
Yeah.
Keep my lord's board discharge or subject to corrections?
I don't know. That's why I'm telling. I don't know how far Mr. Banerjee will continue.
Without the immediate next matter, my lord. Anyway, I'm here.
It will take time, my lord. This
It
much
will
I
take
can say.
time. Then, if nobody is there, I will not pass any adverse order. It will remain in the list.
My lord, the application is the second Order 7 Rule 11 application filed by them, admittedly, in a suit, my lord, which has been filed for, my lord, possession, my lord,
It's
under
the
the...
second application for rejection.
Yes. In a suit, my lord, which was filed in 2016 for possession, my lord, under the Premises Tenancy Act. Now, my lord, the earlier application, my lord, if your lordship takes that order for dismissal, is the word. Hmm? One 176, my lord. 18th of July 2018. My lord, this is volume 2.
376.
176, my lord. Second volume.
Yes.
This application is premature and in any event cannot be decided without evidence. The right of cross-examination of the plaintiff is not lost. Under such circumstances, this application is dismissed. It is, however, made clear that the maintainability of the suit as urged in this application is not decided in this proceeding. So therefore, my lord, the question of maintainability was raised and it was dismissed. So this was the first Order 7 Rule 11 application. Now, my lord, against this, no appeal was preferred. And therefore, this order has attained finality of 18 July 2018. Now, my lord, the need for the second application is otherwise, my lord, for a different reason, which I'll show, my lord. There was an application filed by us under 7(3) of the Premises Tenancy Act, which was allowed. So, my lord, his defense has been struck off. So, once his defense has been struck off, lordship will find that order, my lord, is there. Which double? Give me one moment, my lord. Page double. লাগিয়েছে তো কোথায় তোরা লাগিয়েছিস ডিফেন্স স্টক অফ But I think this is not in dispute. The defense was struck off. My lord, after it was struck off, they filed a recalling application.
Where is the order of struck off?
My lord, that I believe is the annexure E. Page-টা কত? ইন্ডেক্স করলে পারিস লিখে রাখবি $155, I'm told, my lord. Yes, 155. Dated 4th of September 2017. This is an application by the landlord owner for striking out of the defense of the defendant tenant against delivery of possession. The plaintiff is the owner of premises number such and such, measuring such and such. The tenancy of the defendant was terminated by a notice to quit dated 17th March 2016. Thereafter, the suit has been filed for eviction. The same suit, my lord. The writ of summons in the suit was duly served upon the respondent defendant on 31st August 2016. The respondent filed a written statement on 20th December 2016. The respondent did not pay any rent since August 2014 and also have failed and neglected to pay municipal rates and taxes and maintenance. The plaintiff alleged that in view of failure to pay such payment, the defendant became a defaulter under Section 6(1)(b) of the West Bengal Premises Tenancy Act. Defendant neither has deposited the arrears nor, this is very important, nor has filed any application under Section 7(2) of the West Bengal Premises Tenancy Act. Admittedly, my lord, the defendant is enjoying the said property for all these periods without making payment of any rent and or occupation charges. The petitioners contend that although the writ of summons along with the copy of the plaint were received by the respondent on 31st August 2016, but the defendant has failed and neglected to pay the plaintiff or deposit with court all areas of rent calculated at the rate at which it has been last paid and up to the end of the month previous to that in which the payment is made, together with interest at the rate of 10% per annum. It is submitted that the last payment or deposit is required to be made within 1 month of the service of summons on the tenant. The tenant thereafter is required under the statute to pay to the landlord or deposit with the court month by 15th of each succeeding month a sum equivalent to the rent at that rate. The plaintiff says that the defendant did not deposit the said amount within the aforesaid period of 1 month, nor the defendant had made any application under Section 7(2) of the West Bengal Premises Tenancy Act for extension of time to deposit the arrears rent along with interest. On such fact, this application is filed for striking out the defense. In course of hearing, the defendant was asked to produce document to show that the rent either was tendered subsequent to August 2014 or application under Section 7(2) of the West Bengal Premises Tenancy Act 1997 has been filed. So, my lord, the court gave them an opportunity. Now, my lord, defendant, however, failed. So, admitted position that, my lord, neither they could show that they had paid the rent post August 2014, nor, my lord, that they have filed any application under section 7(2) of the West Bengal Premises Tenancy Act. Ultimately, lordship will find the next page, Justice says, my lord,
Prayer of striking out.
yes, the prayer of striking out of the defendant is allowed. So his defense has been struck off in this suit. Now, once the defense has been struck off, I believe no appeal again preferred. No appeal again preferred. What did they do? They filed a recalling application. Lordship will kindly take that application, which they have annexed, which starts from, my lord, page 159. And my lord kindly sees the prayer of that recalling application, which is at page 172. My lord, first I'll show the prayer and then I'll take my lord to the, my lord, paragraphs, my lord. My lord, it says, prayer A, recall the order dated such and such and not to strike off the defense of the petitioner. So recalling was only for this purpose. Now, my lord kindly takes the paragraph, relevant paragraph in this application, which is for the purpose of, my lord, adjudication required. My lord will kindly come, my lord, to paragraph 24, my lord.
25. 23.
23, my lord. My lord kindly comes to 23. 24 is thereafter. I'll read. My lord, at once, your petitioner contacted his learned advocate on record, who advised your petitioner to take out the instant application to seek leave of this honorable court to tender the admitted arrears of rent since August 2014 till date. Accordingly, such application was taken out on 4th September 2017. Your petitioner states that the application being GA number such and such appearing in the list of Honorable Justice Shomen Shen was taken up for hearing on such and such, when the learned junior counsel appearing for the plaintiff sought for, my lord, grounds of illness and all. These are, my lord, all considered. Now, my lord kindly takes the next sentence, which is important. The learned advocate for the defendant prayed for directions to exchange affidavits in the matter and also inform the honorable court that an application under section 7(1) has been ready. So it's not filed. It was never filed. Has been ready, made ready, and shall be filed in course of the day. So as on the date of recalling even, there was no 7(2) application filed by them, admittedly. As on that date even, my lord, there was no 7(2) application filed. So when, my lord, the application was filed for 7(3), there was no application under 7(2). As on the date of recalling also, there was no application under 7(2). That's the averment.
No, this is contradictory. Kindly come to page 20, para 23.
Yes, my lord.
According such application was taken out on 4th September.
Or I am not aware which application this, my lord,
That's
is
why.
they are talking about.
No, because para 23 they have clarified once taken out an application to seek leave of this honorable court to tender the admitted arrears of rent.
So, my lord, even if I go by this averment, lordship is correct, then, my lord, it should have been that it has been filed.
Filed.
And this is the GA number.
GA number.
But then kindly takes, my lord, 169, as I read, has been made ready and shall be filed in course of the day.
Advocate for the exchange of
But I believe the draftsman was trying to, my lord, emphasize on the application which we had filed for striking off. And, my lord, he was saying that on that day the junior had gone and, my lord, Be that as it may, I am, my lord, on the law.
Taken the ground on that day, Junior was there, so that.
Very well.
But it was
My
not
lord, I am on the averment that on the day of the recalling, 7-3 order already passed. My lord, he is being struck off. On the date of recalling also, there is no 7-2 application filed. It is being prepared and will be filed. Too late in the day, but that's the averment. And my lord, accordingly, what does Justice Sen do considering this? Rightly, my lord, the recalling application has been dismissed by Justice Sen. That is, my lord, at page 175.
So this 175 is 3034.
No, my lord, 175, my lord, I'll come to that. My lord, this application for recalling was dismissed, admittedly. Now, my lord, what they do? After that, they go before Justice Sen and file a 7-1 application. That is at 175. Now, my lord, the recalling dismissal also attended finality, no appeal preferred. Now, my lord, the 7-1 application which was filed, which is 3034 of 2017, was dismissed by Justice Sen on 13th of September 2017. Now, my lord, this date is very important because, my lord, when I file the 7-1 application, even, my lord, after my defense has been struck off, I am admittedly subjecting my jurisdiction to the, my lord, court under the Premises Tenancy Act. Admittedly. Because that is what is required for dismissal of this Order 7, Rule 11.
No, only count the base 175.
Yes, my lord.
Page 175 in view of the order passed, in view of the order dated 4 September 2017, passed in GA number 2920.
This application stands dismissed. My lord, at the top, kindly sees the GA 3034. 3034.
What is the 3034 application?
My lord, 3034 is the recalling, which has been dismissed.
Okay.
And my lord, kindly come to paragraph 26. Kindly comes to paragraph 26. Since, my lord, page 170. Since passing of the said order dated 4th September 2017, your petitioner has taken out an application in line was 7-1 of the itself and registered as GA number 2980 of 2017. Now, my lord, this application under 7-1 is when he subjects himself to the jurisdiction of the court under Premises Tenancy Act. And this application is still pending.
2980.
Yes. So, my lord, if an application under 7-1 is pending, then how can somebody come before the court and, my lord, say...
No. So, what is the GA 2920? Page 175.
2980 is, according to his pleading, is the 7-1.
2980 is the 7-1.
Yes.
That is a paragraph 26, page 170.
Yes, my lord.
But kindly come again 175.
175, my lord. I will, my lord. Yes.
In view of the order dated 4 September 2017, passed in GA number 2920.
এটা কি তাই তাহলে এখানে নাম্বারটা ভুল লিখেছে ও তাই না my lord
2935 it should be.
No, it shouldn't be 2935, it should be 2920 because 2935 I am told, my lord, is wrongly recorded. It should be, my lord, 2920 of 2017 because she was there at that point of time.
But page 155 is
Yes,
striking
my
of order. That is 2935 in the cost title also in
এটা কি
the
my lord gives me one more. এটা তাহলে
operative
কি
portion
তুই
also.
ছিলি বাবা 2920 টা কি? Be that as it may, we'll come to that, my lord. 2920 is not, my lord, an hurdle. But the important thing is that if today, my lord, according to his own pleadings in the recalling application, I read paragraph 26, wherein he says that there is an application under 7-1 pending, being GA 2980 of 2017, then in the same breath, one cannot come up before my lord and say that I have filed an order 7, rule 11, dismiss the suit on the ground that it is not governed by the Premises Tenancy Act but under the TP Act. Because, my lord, I cannot subject myself to a jurisdiction and come and say, my lord, reprobate, saying that I will go the other way around. That's not possible. That's not possible. And admittedly, my lord, this application is still pending. Even if it has been dismissed, let us take the worst. My lord, then even the jurisdiction that I had, my lord, subjected to myself. Yes.
Because of admission.
Yes. Now, my lord, apropos this, now, my lord, kindly takes up the matter which is in hand. Now, my lord, in this application, what is his contention? He comes up and says, my lord, what is the background of this case? There was a lease given to one, my lord, company known as Allen Park Properties. Allen Park Properties, my lord, in due course, has given several subleases to all the petitioners. One of them is before my lord. My lord, these disputes were going on. We had obtained a decree. My lord, they came up. Then, my lord, a settlement was reached at. Then, my lord, a settlement agreement was entered into. And in the settlement agreement, my lord, there is a clause which is trying to harp upon. Lordship will kindly take that clause by saying that it has been stated that it will not be under the Premises Tenancy Act. So therefore, how is it that you are filing again, my lord, under the Premises Tenancy Act? My lord, that memorandum of settlement starts from page 60. Now, my lord, kindly comes to page 63. Clause 7. Lordship has got it, my lord. The parties agree that all existing and future leases and subleases in favor of the lessees and or the sublessees, including those executed pursuant to this settlement, shall be governed by the Transfer of Property Act as modified from time to time, and shall not be governed by the West Bengal Premises Tenancy Act 1997 under any circumstances, notwithstanding anything to the contrary contained in any other law for the time being in force. Now, my lord, I write a contract with my learned junior friend saying that you kill X, but you will not be crucified or you not be hanged. Will that prevail in the court of law? There cannot be any estoppel against a statute. Simple logic. This is something who the draftsman, maybe, my lord, does not know the law. He has written something which is not supported by the law, but the court will not look into it. What the court will look into is the law of the land. Now, my lord, kindly sees the rent. The rent, my lord, is stated at the paragraph itself, at the top, my lord, of that page itself, directly to the decree holder, a sum of rupees 1,000 per month per flat. Or if it is rupees 1,000, there is no question of the Transfer of Property Act coming into being. No question at all. What has been written is a wrong proposition of law at best. Now, my lord, I come to the next step. This is the third, my lord, block which they cannot, my lord, pass over. First is, my lord, 7-1 filed, subjected to the jurisdiction of premises tenancy. Second, my lord, there cannot be any estoppel against a statute. So, my lord, it will be under the Premises Tenancy Act. It's 1,000 rupees. Third is, my lord, it's an unregistered lease, which, my lord, is admitted. Now, my lord, a very hilarious submission was made, if I may say, that lease agreement cannot be under Premises Tenancy Act. My lord, kindly takes the Premises Tenancy Act once, my lord. And kindly comes to section 3, my lord. My lord, kindly takes, this is the exemptions under which, my lord, this act will be. Section 3, nothing contained in this act shall apply to any tenancy where the lease, my lord, I am reading C. I'm sorry, my lord, it came into being in 2006. Our agreement that they are relying upon is of 2014. 3C, any tenancy where the lease with due consent of the tenant has been registered, the word is, under the Registration Act after the commencement of this act, and the fact of such consent has been recorded in the instrument so registered. Admittedly, unregistered document does not fall. It says registered. It has to be registered, then the exception, then the act will not apply. But if it is unregistered, the exemption goes. So, my lord kindly takes this document that, my lord, I read out. This is an unregistered document, which is at page 103. It's a notarized document. It's a part, my lord, of the decree, and it's an unregistered terms of settlement. So, my lord, 3 counts. 1, 7-1 subjected to the jurisdiction. 2, my lord, that, my lord, the agreement is against the law and the law will prevail. 3, my lord, is that he doesn't fall under the exemption under section 3. Now, my lord, apropos this, kindly looks the law as it has been settled, my lord, which is there. My lord kindly takes the ওইটা দিয়ে শুরু করো, Antony. Well, this is reported in 2000 volume 6 SCC 394. Well, what happens if there is an unregistered lease? What is his status? Well, his status is that of a statutory tenant. He, my lord, is not, my lord, evicted without due process of law. Neither he is, my lord, to be evicted without having the protection under the law. Both are given to him, but it is under a connotation as a statutory tenant. Now, my lord kindly takes this judgment, identical matter. What happened here, lordship, may I just show? My lord kindly will take paragraph, my lord, 1 itself. A dispute which there are several matters which has gone to the Supreme Court. My lord kindly takes it. A dispute which constantly caused many litigations to prolong in the past, whether a lease could be made by an unregistered instrument, which such deed is compulsorily registrable. So ours may be compulsorily registrable, it's not registered. That's the case. Has once again been raised, and that dispute has lengthened the longevity of this litigation through a checkered career. The successor of the party, who was mainly responsible for not registering the instrument, has now been benefited of it, as the impugned judgment gave a decree for eviction of the person who was admittedly inducted into possession of the building by the former. Though the appellant claimed protection under the provisions of the rent control legislation, the High Court discountenanced it on the premise that the document executed by the parties regarding the transaction is void under law. The simple question now is whether the appellant can claim protection as a tenant under the Kerala Rent Act. Now, my lord kindly sees, my lord, what is, my lord, the facts. The building which is the subject matter of this litigation is described as a shed which originally belonged to a family, the senior member of which inducted the appellant in possession thereof as per a lease dated 4/1/1974, which was ostensibly meant for a period of 5 years. The monthly rent of the building has been fixed at rupees 140. The appellant paid rent of the building at the said rate till October 1974. Sometime during this period, ownership of the building happened to be allotted to a female member of the family as per a partition effected between the parties. Thereafter, the rent of the building was paid by the appellant to the aforesaid Devaki. Subsequently, ownership of the building was transferred by Devaki to the respondent, who filed the suit as plaintiff. For the sake of convenience, respondent can be referred to as plaintiff. The trial court decreed the suit by repelling the contention of the appellant that the suit was not maintainable, as he is protected from eviction under the provisions of the Rent Act. The trial court found that the appellant is not a tenant, as the lease was void on account of non-registration of the lease deed. In the first appeal filed by the appellant, a district judge held that in spite of non-registration of the instrument, there was a valid tenancy of the building and hence the appellant could not be evicted except in accordance with the provisions of the Rent Act. In the second appeal filed by the respondent, a single judge of the High Court of Kerala set aside the judgment of the district judge and remanded the first appeal to that court by holding that the plaintiff was inducted into possession under a void lease and hence the court should consider whether, independent of this lease, the defendant was in possession as a lessee from month to month. Learned single judge pointed out that since it is a question of fact, the same has to be decided on the evidence on record. After the remand, the district court entered upon a finding that despite the defect of non-registration of the instrument, the facts and circumstances of this case and the evidence discussed above could clearly show that the parties intended to create a lease. The district judge further held that the appellant is the tenant as defined in the Rent Act, and hence the plaintiff is not entitled to a decree in this case, and his remedy is to apply before the Rent Control Court. When the matter went up to the High Court again in a second appeal, a learned single judge did not agree with the approach made by the district judge after remand, and following the observations inter alia have been made by the High Court. It has been noted that if the conclusion of this court on the earlier occasion were that payment and acceptance of rent pursuant to the void contract itself would bring about the relationship of landlord and tenant between the parties protected under the Kerala Rent Act, this court would have certainly dismissed the suit filed by the plaintiff by so finding and would not have remanded the appeal to the lower appellate court in the manner in which it was done. The lower appellate court has ignored this aspect while purporting to the record a finding that the first defendant would be a tenant protected by the Rent Act, even if he had paid rent only under the void lease. The same approach by the appellate court appears to be totally unsustainable. Now, my lord, in these facts, kindly takes what the Supreme Court has held. I believe the second appellate court was very angry that the district judge is not listening to him. My lord, kindly takes. Hmm? 11, na?
13, 14.
No, my lord, kindly takes from my lord 12, which is important because that discusses, my lord, with regard to the TP Act, what they are trying to show before my lord. But the above findings do not exhaust the scope of the issue whether the appellant is a lessee of the building. A lease of immovable property is defined in section 105 of the TP Act. A transfer of a right to enjoy a property in consideration of a price paid or promised to be rendered periodically or on specified occasions is the basic fabric for a valid lease. The provision says that such a transfer can be made expressly or by implication. Once there is such a transfer of right to enjoy the property, a lease stands created. What is mentioned in the 3 paragraphs of the first part of section 107 of the TP Act are only the different modes of how leases are created. The first para has been extracted above and it deals with the mode of creating the particular kinds of leases mentioned therein. The third para can be read along with the above as it comes a condition to be complied with if the parties choose to create a lease as per a registered instrument mentioned therein. All other leases, if created, necessarily fall within the ambit of the second para. Thus, dehouse the instrument, parties can create a lease as envisaged in the second part of section 107, which reads thus, all other leases of immovable property may be made either by a registered instrument or by oral agreement accompanied by delivery of possession. So, my lord, registered instrument is something which is mandatory or by oral agreement. When lease is a transfer of a right to enjoy the property and such transfer can be made expressly or by implication, the mere fact that an unregistered instrument came into existence would not stand in the way of the court to determine whether there was in fact a lease otherwise than through such deed. When it is admitted by both the parties that appellant was inducted into the possession of the building by the owner thereof, and that the appellant was paying monthly rent or had agreed to pay the rent in respect of the building, Well, this is very important. The legal character of the appellant's possession has to be attributed to a jural relationship between the parties. That's exactly what we have in this case, since it is an unregistered lease. Such a jural relationship on the fact situation of this case cannot be placed anything different from that of a lessor and a lessee, falling within the purview of the second para of 100 and section 107 of the TP Act extracted above. From the pleadings of the parties, there is no possibility for holding that the nature of possession of the appellant in respect of the building is anything other than as a lease. Then, my lord, see, Sri P. Krishnamurthy, learned senior counsel, contended that a lease need not necessarily be the corollary of such a situation, as possession of the appellant could as well as be permissive. We are unable to agree with the submission on the fact situation of this case that the appellant's possession of the building can be one of mere permissive nature without any right or liabilities attached to it. When it is submitted that legal possession of the building has been transferred to the appellant, there is no scope of countenancing even a case of license. The transfer of right in the building, for the enjoyment of which the consideration of payment of monthly rent has been fixed, can reasonably be presumed. Since the lease could not fall within the first paragraph of 107, it could not have been for a period of exceeding 1 year. The further presumption is that the lease would fall within the ambit of residuary second paragraph of 107 of the TP Act. Taking a different view would be contrary to the reality when parties clearly intended to create a lease through the document which they executed had not gone into the process of registration. That lacuna had affected the validity of the document, but what had happened between the parties in respect of the property became a reality. Non-registration of the document had caused only two consequences. One is that no lease exceeding 1 year was created. Second is that the instrument became useless so far as creation of the lease is concerned. Nonetheless, the permission that a lease not exceeding 1 year stood created by conduct of the parties remains unrebutted. Sri such and such learned counsel cited certain decisions to support this contention that the court did not treat similar transactions as lease. Then, my lord, a contention made by a party to the suit that he had a right under the Local Rent Control Act was negative on the ground that there was no landlord-tenant relationship between the parties. In that decision, this court did not accept the contention that the word, this is important, letting, which was contemplated in the particular Rent Control Act, included not merely a transfer to a tenant, but also to a licensee, or that the word rent precluded the landlord from pleading that there was no relation of landlord and tenant between the parties. The finding made in that case against the plea of landlord was based on the premise that the transfer was not made by the municipal committee in accordance with the law, and hence there was no transfer at all. That's a separate issue altogether, my lord. That decision has no application to the points involved in the present case. Now, my lord, in Technician Studio, a two-judge bench considered the effect of a compromise decree which mentioned that the defendant would come to a direct tenant on a monthly rent of 1,000 and the lease would be for a period of 16 years. This is identical, my lord, to the case that is before my lord. But compromise decree was not registered, nor did the parties execute a lease deed pursuant thereto. The contention in that the case was twofold. First, was that by payment and acceptance of rent during the period of 16 years and monthly tenancy had been created. Second, was that the compromise decree can be treated as part of evidence, part payment under section 53 capital A of the TP Act. This court noted that the High Court has found, in agreement with the finding of the subordinate courts, that payment of rent and acceptance of the same did not create any tenancy. The said fact finding was not disturbed by this court in the particular case. However, their lordships observed therein that whether the relationship of landlord and tenant exists between the parties depends on whether the parties intended to create a tenancy. And the intention has to be gathered from the facts and circumstances of the case, it is possible to find on the facts of a given case that payments made by a transfer in possession were really not in terms of the contract, but independent of it, and this might justify an inference of tenancy in his favor. The question is ultimately one of fact. Found that though a second lease deed executed between the parties is void for want of registration, the tenant would continue to be protected under the relevant Rent Control Act, because on the expiry of the period of the first lease, the tenant has acquired the right of a statutory tenant. That's the exact, my lord, law which is to be followed. None of the observations made in the above decision is in conflict with the view expressed by us. The appellant occupied the building as a tenant and he paid rent to the landlord and continued as such. Hence, with the coming into force of the Rent Act, he became a statutory tenant whose eviction can be considered only when an application is moved in that behalf before the rent control court concerned. We therefore allow the appeal and set aside the impugned judgment of the High Court. So therefore, my lord, all that the court has to look into is, my lord, whether there is a relationship, jural relationship of a landlord and a tenant in an unregistered document. That is all. Now the question will arise later, my lord, in trial, whether it can be taken on evidence or not. That is not to be looked into now. Now lordship has to look into the plaint. Nothing more than that. I find, my lord, my learned friends have, my lord, enclosed, my lord, loads of documents with their application. But in Order 7, Rule 11, what is to be looked into is the plaint. Now, my lord, in that, there is a clear submission that, my lord, the payment is of 1,000 rupees. My lord, that there is a jural relationship of a landlord and a tenant. And, my lord, admittedly, it's an unregistered document. Therefore, at best, he's a statutory tenant. And, my lord, if being a statutory tenant, his rights are covered, my lord, under the Premises Tenancy Act. Now, my lord, the question of, my lord, whether, my lord, his defense has been, my lord, struck off, that's a, my lord, legal remedy which he, my lord, avail of. This is not the appeal court to hear about those issues now, my lord. Then, my lord, comes, my lord, the second judgment which I wish to rely upon, my lord, is that, my lord, it is Amatte Dagdeva, is reported in 1980, Volume 1, Supreme Court Cases 185. My lord, here, may I take, my lord, from, my lord, paragraph 4 onwards, my lord? Or should I, my lord, start on the next day, because this is quite a longish judgment, so I have to, my lord.
Then next.
Yes.
Tomorrow at 2 p.m.
Tomorrow at 2 p.m.
Great.
My lord, give me one more minute. Very well, I'll come back at 2 p.m. tomorrow.
My lord, item number 59.
I will come. Consistent suffering for the plaintiff, consistent suffering for the defendant. The plaintiff has argued the matter at length, but due to paucity of time, argument could not be completed. Fix 12/12/2023 at 2.
My lord, item number 59.
Item number
59. Earlier, the matter was fixed on 8 December at 3:45 p.m. Please kindly fix time.
for what? For what?
It was a argument stage.
Who is for the other side?
Other side, I am for plaintiff. Other
Who is for
side
the other side?
is absent.
So evidence completed.
Our side has completed.
Huh.
Their side will be started.
No, stage of argument.
State of
Evidence have been completed.
GA1.
GA.
GA1.
What is the GA?
GA হচ্ছে judgment on admission.
Who is for the other side? Judgment or admission filed by you, plaintiff.
Yeah, our petition.
When can it be? Other side is not here. Do one thing. I am fixing as a day after tomorrow as to be mentioned. Inform the other side. If the both party will come, then I will fix a date for hearing.
Yes, my lord.
To be mentioned day after tomorrow.
My lord, subject to lordship. Act number 33 and 34, very short matter. But I am the petitioner. There is no other side, my lord. There is some delay in the filing the accounts, my lord, only.
Item number?
33 and 34, my lord. There is only some delay in the filing the accounts and inventory, my lord.
When the probate was granted?
Probate was granted, my lord. Just a minute, my lord. Probate was granted, just a minute, my lord. 2018, my lord. But we have received the order in 2021, my lord, because there is a bond and decree drawn up. That's why, my lord, I have to court delay.
So what about the 2 years? What you
My,
have done?
COVID and my solicitor is a senior citizen, my lord. Because he had gone to that Delhi, my lord, for to his daughter, my lord.
In both the cases?
In both the cases, my lord. But the delay, accounts are ready, my lord, inventory ready. But
where is the matter summon?
Matter summon. Huh? Matter summon. Matter summon there, my lord. Huh?
Item number
Page number 2, my lord. Matter summons.
Item number?
33 and 34, my lord.
33.
Both the similar matters, my lord.
The petitioner has filed the application praying for condoning the delay in filing inventory and accounts and to allow the petitioner to file the inventory and accounts in connection with TS number 6 of 2023 within bracket PLA number 160 of 2010. Consider the submission made by the counsel for the petitioner. Peruse the application. Prayer.
Page 8, my lord, of the petition, my lord.
A and B of the master summon is allowed. Petition is directed to file their statement of account and inventory within when it is ready.
Ready, my lord. But 7 days time because the order will be available, my lord.
From date. GA number 10 of 2023 disposed. Just time. GA 9, item number 34.
Same order, my lord. Much obliged, my lord. Subject.
Yes.
Only one issue, my lord. This is without imputing anything, my lord. What happened today is item number 23, my lord. I was in court 23. So I couldn't come. Mr. Jhunjhunwala was here. He was making submissions. I wanted to log.
Nothing. He has produced that.
I know, my lord. It's returnable on the 5th, my lord. We saw the live streaming from there, but I tried to log in, my lord. My lord, the only thing, my lord, if your lordships could direct your lordship's officer, then in case there's an emergent situation, we cannot follow the entire process of the SOP, my lord, by putting in our name, item number, respondent. So, my lord, we'll not be able to log in. If it's an emergent situation, that is what I had to face today. I'm mentioning this upon notice, my lord, to the other side as well.
No problem. Your name will be recorded.
No, my lord, just only to that effect that in case, my lord, there's an insistence that the SOP has to be followed in such situation, we can't, my lord.
Sorry,
Just
my
to
lord,
draw it to
I
your
have
lordship's
taken,
attention.
sorry,
Nothing.
my lord, I have taken leave, my lord.
So grateful, my lord.